1 describe the provisions relating to the appointment of Attorney General of India. Discuss his functions. Ans. According to Article 76, the President shall appoint a person who is qualified to be appointed a judge of the Supreme Court of India to be Attorney General of India. The Attorney General shall hold office during the pleasure of the President. He shall receive such remuneration as the President may determine. Thus the power to appoint the Attorney General and to remove him from office is vested in the President, but he exercises this power on the advice of the Council of Ministers. Duties of Attorney General. The Attorney General gives advice to the Government of India upon such legal matters as may be referred to him and performs such duties of a legal character as may be assigned to him by the President from time to time. He discharges functions conferred on him by or under the Constitution or any other law. According to the rules made by the President, the Attorney General, in addition, is required to appear on behalf of the Government of India in all cases in the Supreme Court in which the Government of India is concerned. Also, he represents the Government of India in any reference made by President to the Supreme Court under Article 143. The Government of India may also require him to appear in any High Court in any case in which the Government of India is concerned. In the performance of his duties, the Attorney General has the right of audience in all courts in India. He has also the right to speak in and otherwise to take part in the proceedings of either House of Parliament and parliamentary committees. He enjoys all the parliamentary privileges which are available to members of the Parliament. Q40 to discuss the composition of Parliament of India. Discuss about relation between the two houses of Parliament. Ans. According to Article 79 of Constitution, the Parliament of India shall consists of 3 organs: the President, the Council of States, Rajya Sabha, and the House of People, Lok Sabha. The President is not a member of either House of Parliament, yet he is integral part of the Parliament. No bill passed by the Parliament shall become law unless assented by President. Like the English crown, the President is associated with the Parliament of the country. The Rajya Sabha. The Rajya Sabha or Council of State is the upper house of Parliament. The maximum membership of the Rajya Sabha is fixed at 250, of whom 12 shall be nominated by the President and the remainder, i.e. 238, shall be representatives of states and union territories. Article 81. The representatives of states are elected by the members of the legislative assemblies in accordance with the system of proportional representation by means of the single transferable vote. The representatives from the union territories are chosen in such a manner a parliament may by law determine. The allocation of seats to each state or union territory and numbers of seats allocated to each in the Rajya Sabha are specified in the 4th schedule. The 12 nominated persons are chosen by the President from amongst the persons having special knowledge or practical experience in literature, science, art and social service. Article 83. The nominated members do not participate in the election of the President of India. The Vice President of India shall be the ex officio chairman of the Rajya Sabha. The Rajya Sabha shall also elect a member of the House to be a deputy chairman. Article 89. When the office of chairman is vacant or he is acting as the vice president or discharging the function of president, his duties shall be performed by the deputy chairman. If the office of the deputy chairman is also vacant, the duties shall be performed by such member of the Rajya Sabha as the president may appoint for that purpose. The chairman presides over the sittings of the House and in the absence the deputy chairman presides. If both are absent, then such person as may be determined by the rule of procedure of the council, and if no such person is present, such other person as may be determined by the council shall act as chairman. Article 91. A deputy chairman shall vacate his office if he ceases to be a member of the council. He may resign his office by writing to the chairman. He may also be removed from his office by a resolution of the council passed by a majority of all the then member present. Article 90. But such a resolution can only be moved by giving at least 14 days notice. While a resolution for the removal of the chairman, vice president, is under consideration, the deputy chairman shall not preside. The chairman shall have the right to speak and take part in the proceedings, but shall have no right to vote on such resolution or on any other proceedings. Article 92. The Rajya Sabha is a permanent house. Although the Rajya Sabha is a permanent body, but in respect of powers, it enjoys inferior position vis-à-vis the Lok Sabha. A money bill can only be introduced in the Lok Sabha. The Rajya Sabha has no powers in respect of a money bill. A vote of non-confidence cannot be passed against the government by the Rajya Sabha. However, Rajya Sabha fulfill following purposes. 1. It is considered useful because senior politicians and statesmen might get an easy access in it without undergoing the ordeal of general election necessary for the members of Lok Sabha, so that experience and talent is not lost to the country and they may discuss question of public interest. 2. The existence of Rajya Sabha stops the drastic changes in the law of the country made in the heat of monetary passion and affords opportunity for its reconsideration by delaying its adoption for a limited period. 3. The Rajya Sabha is a house where the state are represented keeping with the federal principles. Articles 83, A, B. Lok Sabha. The maximum number of membership of Lok Sabha is fixed at 545. Article 81 provides that out of 545, 525 will be elected members by election in different territorial constituencies in states and 20 members will represent union territories. The members of union territories shall be chosen in such a manner as the Parliament may by law provide. The representatives of the states are chosen by direct election from territorial constituencies in the states on the basis of adult suffrage. The President may, if he is of the opinion that the Anglo-Indian community is not adequately represented in the Lok Sabha, nominate not more than 2 members of that community to the Lok Sabha. Every citizen of India who is not less than 18 years of age shall be entitled to take part in the parliamentary election and shall have right to vote in the election of Lok Sabha, if he is not otherwise disqualified under the Representation of Peoples Act. According to Article 81, 2a, there shall be allotted to each state a number of seats in the Lok Sabha, in such manner that the ratio between that number and the population of the state is, so far as practicable, the same for all states, and b. Each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it, so far as practicable, the same throughout the state. Provided that the provisions of subclause A of clause 2 of Article 81 shall not be applicable for the purpose of allotment of seats in the Lok Sabha to any state so long as the population of the state does not extend to 6 millions. The allocation of seats in the Lok Sabha to each state is determined on the basis of population. The expression population in this article means the population as ascertained at the last preceding census. The reference in this clause to the last preceding census is census of 1971. The Constitution, 42nd Amendment Act, 1976, provides that the seats in the Lok Sabha will be allocated on the basis of 1971 census, and this will continue to be so till the year 2000. This means that there will be no change in the number of seats in the Lok Sabha on the basis of 1981 and 1991 censuses. The amendment provides that the redelimitation of constituencies undertaken after each census shall take effect on such date as the President may by order specify. Seats shall be reserved in the Lok Sabha for the scheduled castes and the scheduled tribes, Article 330. This reservation was made originally for 10 years from the commencement of the Constitution. Now it has been extended to 40 years, Article 334. The normal life of the Lok Sabha is 5 years. This term may be reduced by a dissolution of the House by the President. The normal life of Lok Sabha may be extended where a proclamation of emergency under Article 352 is in operation. Such extension should not exceed 1 year at a time and not exceed in any case beyond a period of 6 months after proclamation of emergency has ceased to be in operation. Article 83. Sessions of Parliament. The President shall from time to time summon each House of Parliament to meet at such time and place as he thinks fit, but 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. Article 85, 1. At the commencement of the first session after each general election to the House of People and at the commencement of the first session of each year the President shall address both Houses of Parliament assembled together and inform Parliament of the causes of its summons. Article 87. The President may address either House of Parliament or both Houses assembled together and for that purpose require the attendance of members. The President may send messages to either Houses of Parliament, whether with respect to a bill then pending in Parliament or otherwise, and a House to which any message is sent shall with convenient dispatch consider any matter required by the message to be taken into consideration. Article 86. Prorogation of the Houses. The President may from time to time prorogue the Houses or either House. Prorogation does not end the life of the House. It only terminates its session. The House may need and consider the pending business. Dissolution of Lok Sabha. The President may, from time to time, dissolve the Lok Sabha. Article 85. However, in actual practice this power is exercised by the Prime Minister and the President dissolves the Lok Sabha on his advice. So long as the Prime Minister is in majority in the legislature, the President is bound to dissolve the Lok Sabha if advised by him. But if the Prime Minister loses the majority in the House or defeated in a vote of no confidence, the President will not be bound to dissolve the Lok Sabha on the advice of such a Prime Minister. In such a case, the President may exercise his own discretion. Q. 43. What are the qualifications for membership of Parliament? What are their disqualification? Ans. Qualification for membership of Parliament. A person for being chosen as a member for Parliament must be a citizen of India, b. not less than 30 years of age in the case of the Council of States, and not less than 25 years of age in the case of House of the People, c. possessing such other qualification as may be prescribed by Parliament, d. taken an oath before some person authorized in that behalf by the Election Commission according to form set out for the purpose in 3rd Schedule. Article 84. The Representation of Peoples Act, 1951, requires that a person's name should be registered as a voter in any parliament constituency. The constituency does not prescribe any educational qualification for membership of parliament. Disqualifications: a person is disqualified for being chosen and for continuing as a member of parliament if he suffers from following disqualifications. Article 102. A. If he holds any office of profit under central or the state government other than an office declared by Parliament by law not to disqualify its holder. Article 102. 1. B. If he is of unsound mind and a competent court has declared him to be so. C. If he is an undischarged insolvent. D. If he is not a citizen of India, or has voluntarily acquired the citizenship of a foreign state, or under any acknowledgement of allegiance or adherence of a foreign state. E. If he is so disqualified under any law made by Parliament. For this purpose, Parliament has prescribed the necessary disqualifications in the Representation of People's Act, 1951. A minister in the central or the state government is not considered as holding the office of profit. Article 102. 2. Disqualifications under the Representation of People's Act are: 1. Corrupt practice at an election. 2. Conviction for an offence resulting in imprisonment for 2 or more years. 3. Failure to lodge an account for election expenses. 4. Having an interest or share in the contract for supply of goods or execution of any work or performance of a service to the government. 5. Being a director or managing agent or holding an office of profit in a corporation in which the government has 25% share. 6. Dismissal from government service for corruption or disloyalty to the state. Disqualification on ground of defection. The 52nd Amendment has amended Articles 101, 102, 190 and 191 and added a new schedule, the 10th schedule to the Constitution, which specifies the disqualifications on the ground of defection. The amendment has added a new clause, 2, to Articles 102 and 191, which provide that a member shall be disqualified for being a member of either House of Parliament or of state legislatures if he incurs the disqualifications specified in the 10th schedule. 1. If he voluntarily gives up the membership of the political party on whose ticket he is elected to the House, or 2. If he votes or abstains from voting in the House against any direction of the political party or by any person or authority authorized by it in this behalf, without the prior permission of such party, and unless it has been condoned by the party within 15 days from the date of voting or abstention, or 3. If any nominated member joins any political party after the expiry of 6 months from the date on which he takes his seat in the House. Exceptions: the above disqualification will however not apply. 1. If a member of Parliament or state legislature goes out of his party as a result of a split in the original party, provided such group consists of not less than 1/3 of the total membership of that party in the House. 2. If a member goes out as a result of a merger of his original political party with another political party, provided 2/3 of the members of the legislature party have agreed to such merger. Or 3. If a member, after being elected as the presiding officer, gives up the membership of the party to which he belonged, or does not rejoin that party, or becomes a member of another party. Decision on questions of disqualification of members. Article 103 provides that if any question arises as to whether a member of either House of Parliament has become subject to any disqualification mentioned under Article 10, the question shall be referred to the President, whose decision shall be final. However, the President is required to obtain the opinion of the Election Commission before giving any decision on matter of qualifications, and shall act according to it. According to Article 101, when a sitting member becomes subject to a disqualification after his election, he will ipso facto cease to be member and his seat shall become vacant. No person can be a member of both Houses of Parliament at the same time. If a person is elected member of both Houses of Parliament, the Parliament may provide by law in which houses he will vacate his seat. No person can be a member of both the Parliament and the State Legislature. If a person is so elected, then, at the expiry of such time as the President may by rule specify, that person's seat in the Parliament shall become vacant unless he has previously resigned his seat in the State Legislature. Article 101, 2. The Representation of Peoples Act, 1951, provides that if a person is elected to both Houses of Parliament, he must intimate within 10 days from the publication of the election result in which House he desires to serve. Q. 44 discuss the legislative powers of the Parliament under the Indian Constitution. Ans. The most important functions of the Parliament is the making of laws. The legislative powers of the Parliament is initiated through procedure for introduction and passage of a bill. The bills may be of two kinds. A. Ordinary bills. B. Money bills. A. Procedure for passing ordinary bills, except money bills and other financial bill. A bill may originate in either House of Parliament. Such a bill shall not be deemed to have been passed by the Houses of Parliament unless it has been agreed to by both Houses, either without amendment or with such amendments only as are agreed to by both Houses. A bill pending in Parliament shall not lapse by reason of prorogation of the Houses. A bill pending in the Rajya Sabha which has not been passed by the Lok Sabha shall not lapse on the dissolution of the Lok Sabha. A bill which is pending in Lok Sabha or which having been passed by the Lok Sabha is pending in Rajya Sabha shall, subject to the provision of Article 108, lapse on the dissolution of the Lok Sabha. Article 107. Joint sitting of both houses in certain cases. Article 108 provides that if after a bill has been passed by one house and transmitted to the other house, A. The bill is rejected by other house, or B. The houses have finally disagreed as to the amendments to be made in the bill. C. More than 6 months have elapsed from the date of the reception of the bill by the other house without the bill being passed by it. Where the President has under clause 1 notified his intention of summoning the houses to meet in a joint sitting, neither house shall proceed further with the bill, but the President may at any time after the date of his notification summon the houses to meet in a joint sitting for the purpose specified in the notification, and if he does so, the houses shall meet accordingly. If at joint sitting of the houses, the bill with such amendments, if any, as agreed in the joint sitting is passed by majority of the total number of members of both houses present and voting, it shall be deemed to have been passed by both houses for the purpose of this Constitution. Special procedure in respect of money bills. A money bill shall not be introduced in the Council of States except on the recommendation of the President. Article 117, 1. After a money bill has been passed by the Lok Sabha, it shall be transmitted to the Rajya Sabha for its recommendations, and the Rajya Sabha shall within a period of 14 days from the date of its receipt return the bill to the Lok Sabha with its recommendations, and the Lok Sabha may thereupon either accept or reject all or any of the recommendations of the Rajya Sabha. If the Lok Sabha accepts any of the recommendations of the Rajya Sabha, the money bill shall be deemed to have been passed by both houses with the amendments recommended by the Rajya Sabha and accepted by the Lok Sabha. If the Lok Sabha does not accept any of the recommendations of the Rajya Sabha, the money bill shall be deemed to have been passed by both houses in the form in which it was passed by the Lok Sabha without any of the amendments recommended by the Rajya Sabha. If a money bill passed by the Lok Sabha and transmitted to the Rajya Sabha for its recommendations is not returned to the Lok Sabha within the said period of 14 days, it shall be deemed to have passed by both houses at the expiration of the said period in the form in which it was passed by the Lok Sabha. Article 109. Rajya Sabha thus enjoys only a recommendatory authority over the passage of money bill. It is not authorized to reject or amount money bill passed by the Lok Sabha. Assent to bills. When a bill has been passed by both the Houses of Parliament, it shall be presented to President, and the President shall declare either that he assents to the bill or that he withholds assent therefrom. The President may as soon as possible, after the presentation to him, a bill for assent, return the bill, if it is not money bill, to the Houses with a message requesting that they will reconsider the bill or any specified provision thereof, and in particular will consider the desirability of introducing such amendments as he may recommend in his message, and when a bill is so returned, the House shall reconsider the bill accordingly, and if the bill is passed again by the Houses with or without amendment and presented to President for assent, the President shall not withhold assent therefrom. Article 111. Q. 45 Right note on Money Bill. Ans. Money Bill Article 110. 1. Defines that a money bill is a bill which contains only provisions with respect to all or any of the following matters. A. The imposition, abolition, remission, alteration or regulation of any tax. B. The regulation of the borrowing of money or the giving of any guarantee by the Government of India. C. The custody of the consolidated fund or the contingency fund, the payment or withdrawal of money from such fund. D. The appropriation of money out of the consolidated fund of India. E. The declaring of any expenditure to be charged on the Consolidated Fund of India. F. The receipt of money on account of the Consolidated Fund of India, or the public account of India, or the custody or issue of such money, or the audit of the accounts of the Union or of a state. G. Any matter incidental to any of the matters specified in sub-clauses A to F. But a bill is not money bill by reason only that it provides for A. The imposition of fines or other pecuniary penalties, or B. The payment of fees for license or service rendered, or C. Imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. Article 113, 2. If any question arises whether bill is a money bill or not, the decision of the Speaker of the Lok Sabha shall be final. So when a bill is sent to the Rajya Sabha or presented to the President for assent, a certificate of the Speaker shall be endorsed on it that it is a money bill. Article 110, 4. A money bill can only be introduced in the Lok Sabha. It cannot be introduced in Rajya Sabha, Article 1091. A money bill can only be introduced with the recommendation of the President. However, no recommendation of the President is necessary for the moving of an amendment taking provision for the reduction or abolition of any tax. Article 117. 1. Proviso. After a money bill has been passed by the Lok Sabha, it is sent to the Rajya Sabha for its recommendations. The Rajya Sabha must return the bill to the Lok Sabha within 14 days from the receipt of the bill with its recommendation. The Lok Sabha may either accept or reject all or any of the recommendations of the Rajya Sabha. If the Lok Sabha accepts any of the recommendations by the Lok Sabha, the money bill shall be deemed to have been passed by both houses with the amendments by the Rajya Sabha and accepted by the Lok Sabha. If a money bill passed by the Lok Sabha and sent to the Rajya Sabha for its recommendations is not returned to the Lok Sabha within 14 days, the bill shall be deemed to have been passed by both houses at the expiration of the said 14 days period in the form in which it was passed by the Lok Sabha. Thus the Rajya Sabha can at most detain a money bill for 14 days only. Article 109. If the Lok Sabha rejects all the recommendations of the Rajya Sabha, the bill shall be deemed to have been passed by both houses in the form in which it was passed by the Lok Sabha. Then it will be presented to the Q46. What do you understand by the annual financial statement and what is the procedure in respect of it? Ans. Annual Financial Statement Budget. Article 112. According to Article 112, the President shall in respect of every financial year cause to be laid before both the Houses of Parliament an annual financial statement commonly known as the budget. This statement gives out the estimated income and expenditure for that year. This estimated expenditure is shown separately under two heads. A. The sums charged upon the Consolidated Fund of India and B. The sums required to meet other expenditure out of the Consolidated Fund of India. The expenditure or revenue account should also be distinguished from the other expenditures. The following expenditures are charged on the Consolidated Fund of India. 1. The salary and allowances of the President and other expenditure relating to his office. 2. Salaries and allowances of the Chairman and Deputy Chairman of the Rajya Sabha and the Speaker and the Deputy Speaker of the Lok Sabha. 3. Debt charges for which the Government of India is liable. 4. Salaries, allowances and pensions payable to judges of the Supreme Court, the Controller and Auditor General of India, judges of the High Courts and Federal Court. 5. Any sums required to satisfy any judgment, decree or award of any court or tribunal. 6. Any other expenditure declared by this Constitution or by Parliament by law to be so charged. Discussion and voting on budget. According to Article 113, the expenditure, which is charged on the Consolidated Fund of India, shall not be submitted to the vote of Parliament. However, Houses are not prevented from discussing any of these items of expenditure. Appropriate bills. No money can be taken out from the Consolidated Fund of India unless the Appropriation Act is passed. Article 114, 3. Therefore, after the demands for grants under Article 113 are passed by the Lok Sabha, a bill known as Appropriation Act is introduced in the Lok Sabha. The bill specifies all the grants made by the Lok Sabha, the expenditure charge on the Consolidated Fund of India, as shown in the previous statement before Parliament. But no amendment shall be proposed to the appropriation bill which will have the effect of varying the amount or altering the destination of any grant so made or of varying the amount of any expenditure charged on the Consolidated Fund of India. Supplementary additional or excess grants, Article 115, if the amount authorized by the Appropriation Act to be expended for a particular service is found to be insufficient for the purposes of that year, or when a need has arisen during the current financial year upon some new service not contemplated for that year, for any additional expenditure, a supplementary grant is made by Parliament. The procedure is the same for both the Appropriation Act and the supplementary grant. Votes on account, votes on credit, an exceptional grant before the Appropriation Act is passed, no money is to be withdrawn from the Consolidated Fund of India. But the government may need money to spend before it is passed. Accordingly, under Article 116(a), the Lok Sabha can grant a limited sum from the Consolidated Fund of India to the executive to spend till the Appropriation Act is passed by Parliament. Under Clause B, the Lok Sabha can make a grant for meeting an unexpected demand upon the resources of India when, on account of the magnitude or the indefinite character of the service, the demand cannot be stated with details ordinarily given in the annual financial statement. Under Clause 3, the Lok Sabha has the power to make exceptional grant which forms no part of the current service of any financial year. However, it is necessary that Parliament shall make a law for withdrawal of money from the Consolidated Fund of India for the purpose. The Lok Sabha has sanctioned the grants either by Annual Appropriation Act or Supplementary Grant, Excess Grant, Votes on Account, Votes on Credit or Exceptional Grant. Q. 47 Discuss the Constitution of Supreme Court of India. Describe the qualification, tenure and the procedure for removal of a judge of the Supreme Court. Ans. The essence of a federal constitution is the division of powers between the central and state governments. The division is made by a written constitution, which is the supreme law of the land. Since language of the Constitution is not free from ambiguities and its meaning is likely to be interpreted differently by different authorities at different times, it is but natural that disputes might arise between the centre and its constituent units regarding their respective powers. Therefore, in order to maintain the supremacy of the Constitution, there must be an independent and impartial authority to decide disputes between the centre and the states or the states inter se. This function can only be entrusted to a judicial body. The Supreme Court under our Constitution is such an arbitration. It is the final interpreter and guardian of the Constitution. Composition of the Court. Article 124 of our Constitution provides that the Supreme Court of India shall consist of a Chief Justice of India and 25 other judges until the number of judges is increased. Appointment of judges. The judges of the Supreme Court are appointed by the President. The Chief Justice of the Supreme Court is appointed by the President with the consultation of such of judges of the Supreme Court and the High Courts as he deems necessary for the purpose. But in appointing other judges, the President shall always consult the Chief Justice of India. He may consult such other judges of the Supreme Court and High Courts as he may deem necessary. Article 124, 2. So under Article 124, 2, the President, in appointing other judges of the Supreme Court, is bound to consult the Chief Justice of India. But in appointing the Chief Justice of India, he is not bound to consult anyone. The word may used in Article 124 makes it clear that it is not mandatory on him to consult anyone. The appointment and transfer of judges' cases to in re-presidential reference, AIR 1999 SC 1 and 9 Judge Bench of the Supreme Court has unanimously held that the recommendation made by the Chief Justice of India on the appointment of judges of the Supreme Court and the High Courts without following the consultation process are not binding on the government. The court also widened the scope of the Chief Justice's consultation process, upholding the government's stand on consultation process. The court gave its opinion on the 9 questions raised by the President in his reference to the Supreme Court under Article 143 of the Constitution. The President had sought the Supreme Court's clarification on the consultation process, as laid down in SC Advocate's case for the appointment and transfer of judges following a controversy over the recommendation by former Chief Justice of India M.M. Pujjati. The BJP government did not agree with his recommendation and referred the matter for the Supreme Court's opinion. The court held that the consultation process to be adopted by the Chief Justice of India requires consultation of plurality of judges. The expressions consultation with the Chief Justice of India in Articles 217(1) and 222(1) of the Constitution of India requires consultation of with plurality of judges in the formation of opinion of the Chief Justice of India. The sole individual opinion of the Chief Justice of India does not constitute consultation within the meaning of the said articles. The majority held that in regard to the appointment of judges to the Supreme Court under Article 124(2), the Chief Justice of India should consult a collegium of 4 senior-most judges of the Supreme Court, and made it clear that if 2 judges give adverse opinion, the Chief Justice should not send the recommendation to the government. The collegium must include the successor Chief Justice of India. The opinion of the collegium must be in writing, and the Chief Justice of India should send the recommendation to the President along with his own recommendations. The recommendations of the collegium should be based on a consensus, and unless the opinion is in conformity with that of the Chief Justice of India, no recommendation is to be made. In regard to the appointment of judges of the High Courts, the court held that the collegium should consist of the Chief Justice of India and any 2 senior-most judges of the Supreme Court. In regard to transfer of High Court judge, the court held that in addition to the collegium of 4 judges, the Chief Justice of India is required to consult Chief Justices of the 2 High Courts, one from which the judge is being transferred and the other receiving him. The court held that the appointment of the judges of higher courts can be challenged only on the ground that the consultation power has not been in conformity with the guidelines laid down in the 1993 judgment and as per opinion given in 1999 decision I, without consulting 4 senior-most judges of the Apex Court. The decision of the Supreme Court has struck a golden rule. It has made the consultation process more democratic and transparent. Qualification of a judge. According to Article 124(3), a person shall not be qualified for appointment as a judge of the Supreme Court unless he is a citizen of India and a. has been at least 5 years a judge of a high court or 2 or more such courts in succession, or b. has been for 10 years at least as an advocate of a high court or 2 or more such courts in succession, or c. is in the opinion of the President, a distinguished jurist. Removal of a judge. According to Article 124(4), a judge of Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than 2/3 of the members of that House present, and voting has been presented to President in the same session of such removal on the ground of proved misbehavior or incapacity. Article 124(5) provides that Parliament may by law regulate the procedure of the presentation of an address and for the investigation and proof of misbehavior or incapacity of a judge under Clause 4. According to Article 124(6), every person appointed to be a judge of the Supreme Court shall before he enters upon his office make and subscribe before the President or such other person appointed in this behalf by him on oath or affirmation according to form set out for the purpose in the third schedule for allegiance to the Constitution and faithful performance of duties without fear or favor. No person who has held the office of a judge of the Supreme Court shall plead or act in any court or before an authority within the territory of India. In a historic judgment in K. Veeraswamy v. Union of India, 1991, 3 SCC 655, a 5-judge bench of the Supreme Court, by a majority of 4-1, has held that a judge of the Supreme Court and High Court can be prosecuted and convicted for criminal misconduct. Mr. Veeraswamy was the Chief Justice of the Madras High Court in 1969. In 1976, the CBI registered a case against him charging him with amassing wealth disproportionate to his known income and had thus committed an offence under the Prevention of Corruption Act. When he came to know these developments, he proceeded on leave from 9 March 1976 and subsequently retired on 8 April 1976. The appellant filed a petition in the High Court for quashing the FIR filed by CBI, which was dismissed. He went to Supreme Court by way of special leave petition. The Supreme Court dismissed the appeal against the Madras High Court and ordered his prosecution. The expression misbehavior in Article 124(5) includes criminal misconduct defined in the Prevention of Corruption Act. The expression public servant in Section 6(1)(c) and 2 includes judges of the High Court and the Supreme Court. The Judges' Inquiry Act 1968, enacted by Parliament under Article 124(5) and the Judges' Inquiry Rules 1969 made thereunder provide for removal of a judge on the ground of proved misbehavior or inability. It does not provide for prosecution of a judge for offences under Section 5(1)(e) of the Prevention of Corruption Act. Q. 48 described the nature and scope of jurisdiction of Supreme Court in respect of intergovernment disputes. Ans. The Supreme Court of India is a court of record as provided in Article 129 of the Constitution. Dr. Ambedkar defined a court of record as a court the record of which are admitted to be of evidentiary value and they are not to be questioned when they are produced before any court. Article 129 further provides that the Supreme Court shall have all the powers of such a court, including the power to punish for its contempt. This power necessarily follows from that position of the Supreme Court. Jurisdiction. The Supreme Court of India has 3 kinds of jurisdiction. I. Original. 2. Appellate. 3. Advisory. I. Original jurisdiction. Article 131 deals with the original jurisdiction of the Supreme Court. The cases of intergovernment disputes come under its original jurisdiction. The Supreme Court shall have, to the exclusion of any other court, original jurisdiction in any dispute. A. Between the Government of India and one or more states, or B. Between the Government of India and any state or states on the one side and one or more other states on the other, or C. Between 2 or more states. The Supreme Court in its original jurisdiction cannot entertain any suit brought by private individual against the Government of India. The dispute relating to the original jurisdiction of the court must involve a question of law or fact on which the existence of legal right depends. This means that the court has no jurisdiction in matters of political nature. A legal right means a right recognized by law and capable of being enforced by the power of a state but not necessarily in a court of law. The original jurisdiction of the Supreme Court, however, does not extend to the following matters. 1. The jurisdiction of the Supreme Court shall not extend to a dispute arising out of any treaty, agreement, covenant, engagement, sanad, or other similar instrument which was executed before the commencement of the Constitution and continues to be in operation, or which provides that the jurisdiction of the Supreme Court shall not extend to such a dispute. 2. Under Article 264, Parliament may by law exclude the jurisdiction of the Supreme Court in disputes with respect to the use, distribution or control of the water of any interstate river or river valley. 3. Matters referred to the Finance Commission under Article 280. 4. Matters regarding adjustment of certain expenses between the Union and the State under Article 290. Q49 discuss the civil and constitutional and criminal appellate jurisdiction of Supreme Court. Also discuss regarding special leave to appeal. Ans. Appellate jurisdiction. Article 130 to the Supreme Court is the highest court of appeal in the country. The written decrees of the court run throughout the country. The appellant jurisdiction of the Supreme Court can be divided into four main categories. 1. Constitutional matters. 2. Civil matters. 3. Criminal matters. 4. Special leave to appeal. 1. Appeal in constitutional matters. Under Article 132, 1. An appeal shall lie to the Supreme Court from any judgment, decree or final order, or a High Court, whether in civil, criminal or other proceedings, if the High Court certifies under Article 134- that the case involves a substantial question of law as to the interpretation of this Constitution. Where such a certificate is given, any party in the case may appeal to the Supreme Court on the ground that any such question as aforesaid has been wrongly decided. The object of the new Article 1340 is to avoid delay in granting certificate by the High Court for appeal to the Supreme Court. Under Article 134- the High Court can grant a certificate for appeal to the Supreme Court under Article 132 either on its own motion or on oral application of the aggrieved party immediately after passing the judgment, decree or final order. Prior to this, the High Court could do so only on the application of the aggrieved party. Under Article 132, 1. 3 conditions are necessary for the grant of certificate by the High Court. 1. The order appealed must be against a judgment, decree or final order made by the High Court in civil, criminal or other proceedings. 2. The case must involve a question of law as to the interpretation of this Constitution, and 3. If the High Court under Article 134- certifies that the case be heard by the Supreme Court. 2. Appeal in civil cases. Article 133 provides that an appeal shall lie to the Supreme Court from any judgment, decree or final order in a civil proceeding of a High Court only if the High Court certifies under Article 134-A. That the case involves a substantial question of law of general importance, and 2. That in the opinion of the High Court the said question needs to be decided by the Supreme Court. The Constitution, 30th Amendment Act, 1972, has removed the condition of monetary value that an appeal could go to the Supreme Court only when the amount or value in dispute was not less than 20,000 rupees. Under the amended provision of Article 133, Now an appeal could go to the Supreme Court only if the High Court certifies under Article 134- that the case involves the substantial question of general importance. In Kiranmal v. Dayanoba, AR 1983 SC 461, the High Court dismissed the appeal by one word, order dismissal against the judgment of the civil judge. The Supreme Court found that the appellant could have raised serious question of law and facts before the High Court, and therefore held that it was a fit case which ought to be admitted and disposed of on merits. The case was remitted to the High Court for disposal on merits. The expression civil proceedings means proceedings in which a party asserts the existence of a civil right. The civil proceeding is one in which a person seeks to remedy by an appropriate process the alleged infringement of his civil rights against another person or the state, and which, if the claim is proved, would result in the declaration express or implied of the right claimed and relief, such as payment of debt, damage, compensation, etc. There is no ground for restricting the expression civil proceedings only to those proceedings which arise out of civil suits in proceedings which are tried as civil suits. Accordingly, a proceeding before a High Court under Article 226 for the grant of writ constitutes a civil proceeding. In an appeal under Article 133, the appellant cannot be allowed to raise new grounds not raised before the lower court. No appeal shall lie, unless Parliament by law otherwise provides to the Supreme Court from the judgment, decree or final order of a single judge of a High Court. This prohibition can be removed by Parliament by law. Such a law will not be an amendment of the Constitution. 3. Appeal in criminal cases. Article 134. According to Article 134, an appeal lies to the Supreme Court from any judgment, final order or sentence in a criminal proceeding of a High Court in the following two ways. A. Without a certificate of High Court. B. With a certificate of the High Court. A. Without a certificate. Article 134. A. B. An appeal lies to the Supreme Court without the certificate of the High Court if the High Court A. Has no appeal reversed an order of acquittal of an accused person and sentenced him to death. B. Has withdrawn for trial before itself any case from any court subordinate to its authority and has in such trial convicted the accused person and sentenced him to death. But if the High Court has reversed the order of conviction and has ordered the acquittal of an accused, no appeal would lie to the Supreme Court. B. With a certificate. Article 134. C. Under Clause C. An appeal lies to the Supreme Court if the High Court certifies under Article 134- that it is a fit case for appeal to the Supreme Court. The power of the High Court to grant fitness certificate in the criminal cases is a discretionary power, but the discretion is a judicial one and must be judicially exercised along with the well-established lines which govern these matters. It is to be noted that under Article 134(1)(c), the Supreme Court is not constituted as General Court of Criminal Appeal. A limited criminal appellate jurisdiction is conferred upon the Supreme Court by Article 134. Parliament is empowered under Article 134 to extend the appellate jurisdiction of the Supreme Court in criminal matters. In exercise of the powers under Clause 2 of Article 134, Parliament has enacted the Supreme Court Enlargement of Criminal Appellate Jurisdiction Act, 1970. Section 2 of the above Act provides, without prejudice to the powers conferred on the Supreme Court by Clause 1 of Article 134 of the Constitution, an appeal shall lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding of a High Court in the territory of India if the High Court A. has on appeal reversed an order of acquittal of an accused person and sentenced him to imprisonment for life or to imprisonment for a period of not less than 10 years. B. has withdrawn for trial before itself any case from any court subordinate to its authority and has in such trial convicted the accused person and sentenced him to imprisonment for life or to imprisonment for a period of not less than 10 years. 4. Appeal by special leave under Article 136. The Supreme Court is authorized to grant in its discretion special leave to appeal from A. any judgment, decree, determination, sentence or order. B. in any case or matter. C. passed or made by any court or tribunal in the territory of India. This article vests very wide powers in the Supreme Court. The power given under this article is in the nature of a special residuary powers which are exercisable outside the purview of ordinary law. Articles 130 to 135 deals with ordinary appeals to the Supreme Court in cases where the needs of justice demand interference by the highest court of the land. This article is worded in the widest possible terms. It vests in the Supreme Court a plenary jurisdiction in the matter of entertaining and hearing appeals by granting special leave against any kind of judgment or order made by any court or tribunal, except a military tribunal, in any proceedings, and the exercise of this power is left entirely to the discretion of the court unfettered by any restrictions, and this power cannot be curtailed by any legislation short of amending the article itself. Q. 50 discuss about advisory jurisdiction of the Supreme Court and powers of Supreme Court to review its own judgment or order and making rules. Ans. Advisory jurisdiction. Article 143 of the Constitution vests in the Supreme Court on advisory jurisdiction. According to Clause 1 of Article 143, whenever it appears to the President that a question of law or fact has arisen or is likely to arise, which is of such nature and of such public importance that it is expedient to obtain the opinion of Supreme Court upon it, he may refer it to the court for consideration. The court then may, after such hearing as it thinks fit, report to the President its opinion thereon. Under Clause 2 of this article, a matter which is excluded from the Supreme Court's jurisdiction under Article 131 may be referred to it for opinion, and the court shall, after such hearing as it thinks fit, report to the President its opinion thereon. In Clause 1 of Article 143, the use of the word may indicates that it is not obligatory on the Supreme Court to make a report on the reference made to it. The court has the discretion in the matter and may in proper case, for good reasons, decline to express any opinion on the question submitted to it. However, in Clause 2, the word used is shall, which indicates that it is obligatory for the court to give its opinion on a reference made thereunder. The experience of a few other countries may be useful and instructive in this respect. The U.S. Supreme Court has consistently refused to pronounce advisory opinions on abstract legal questions. The High Court of Australia has also refused to exercise advisory opinion. But to some extent the same purpose is achieved by permitting an Attorney General to bring proceedings in the High Court to secure a determination of the validity of national or state legislation after its passage by the legislature, whether before or after it has entered into force. In the light of this foreign experience, the Supreme Court of India has considered the matter of its advisory jurisdiction in Re Kerala Education Bills, 1957, AIR 1958 SC 956. Following propositions may be called out from its observations therein. 1. The Supreme Court may in proper case for good reasons decline to express an opinion on a reference made to it under Article 143, 1. 2. The question validity of a bill rather than statute in force may be referred to the court for Article 143, 1. Thus contemplate reference to a question of law that is likely to arise. 3. It is for the President to determine what question should be referred to the court. The court cannot go beyond the reference. Up to the year 2001, the President has made 11 references to Supreme Court. The important among them are Re Delhi Laws Act case in 1951, Re Kerala Education Bills, 1958, Re Berubri case in 1956, Keshav Singh case in 1965, the Special Court Reference case in 1978. In 1993, President of India has made a reference to the Supreme Court to express its opinion in Ayodhya Temple Mosque case. In a landmark judgment in Ismail Farooqi v. Union of India, 1994, 6 SCC 360, the 5-judge bench of the Supreme Court comprising held that the presidential reference seeking the Supreme Court's opinion on whether a temple originally existed at the site where the Babri Masjid subsequently stood was superfluous and unnecessary and opposed to secularism and favored one religious community and therefore does not require to be answered. Power to review its judgment. The Supreme Court can review its own judgment or order. Article 137. A review will lie in Supreme Court on 1. Discovery of new and important matters or evidence. 2. Mistake or error apparent on the face of record. 3. Any other sufficient reason. In Adi Sagar v. V.V. Nagari, AIR 1976, SC 2183, Supreme Court point out that a judgment of the final court is final. A review of such a judgment is an exceptional phenomenon, permitted only where a grave and glaring error is made out. The judgment of the Supreme Court will be binding on all courts in India. The expression all courts within the territory of India clearly means courts other than the Supreme Court. Thus, the Supreme Court is not bound by its own decisions and may in proper case reverse its previous decisions. In the case of Bengal Immunity Co. v. State of Bihar, AIR 1955 SC 661, the court held that there is nothing in the Indian Constitution which prevents the Supreme Court departing from its previous decision if it is convinced of its error and its beneficial effect on the general interest of public. The court said, the Supreme Court should not lightly dissent from its previous decisions. Its power of review must be exercised with due care and caution and only for advancing the public well-being in the light of surrounding circumstances of each case brought to its notice, but it is not right to confine its power within rigidly fixed limits. Thus it is clear that the doctrine of precedent, stare decisis, is followed in India to a limited extent. Q. 51 discuss the qualification, appointment, tenure and conditions of office of governor of a state. Ans. Article 153 of the Constitution provides that there shall be a governor for each state, provided that nothing in this article shall prevent the appointment of the same person as governor for 2 or more states. According to Article 155, the governor of a state shall be appointed by the President by warrant under his hand and seal. No person shall be eligible for appointment as governor unless he is a citizen of India and has completed the age of 35 years, Article 156. The governor will hold office for a term of 5 years, provided that a governor shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. The governor shall hold office during the pleasure of the President. Conditions of office of the governor. According to Article 158, the conditions of office of the governor will be as follows. 1. The governor shall not be a member of either House of Parliament or of a House of the Legislature of any state specified in the first schedule, and if a member of either House of Parliament or of a House of the Legislature of any such state be appointed governor, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as governor. 2. The governor shall not hold any other office of profit. 3. The governor shall be entitled without payment of rent to the use of his official residences and shall be also entitled to such emoluments, allowances, and privileges as may be determined by Parliament by law, and until provision in that behalf is so made, such emoluments, allowances, and privileges as are specified in the second schedule. 4. The emoluments and allowances of the governor shall not be diminished during his term of office. According to Article 159, every governor and every person discharging the functions of the governor shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of the High Court exercising jurisdiction in relation to the state, or in his absence the senior most judge of that court available on oath or affirmation in the prescribed form. Q. 50 to discuss the powers and position of the governor of a state under the Constitution of India. Ans. Powers of governor. The head of the state is known as governor. His powers are analogous to those of the President with certain important distinctions. The President is elected to his office, while governors are appointed by the President and hold office during his pleasure and may be dismissed from office by him. The powers of a governor may be classified under the following 4 heads. 1. Executive. 2. Legislative. 3. Financial. 4. Judicial. 1. Executive powers. The executive powers of the state is vested in the governor to be exercised by him either directly or through officers subordinate to him. Article 154. All executive actions shall be expressed to be taken in his name. The executive power of a state shall extend to matter in respect to which the legislature of a state has power to make laws. In any matter with respect to which both the legislature of a state and Parliament have powers to make laws, i.e., if a matter mentioned in the concurrent list, the executive power of the state shall be subject to and limited by the executive powers conferred by the Constitution or by any law made by Parliament upon the Union or authorities thereof. Article 162. The governor appoints the chief minister and other ministers on the advice of chief minister. The ministers hold office during the pleasure of the governor. The council of ministers is, however, responsible to the state legislature or to the lower house of such legislature where the legislature consists of 2 chambers. This means that so long the ministers enjoy the confidence of the legislature, they cannot be dismissed by the governor. This makes the governor a constitutional head like the President of India. 2. Legislative power. The governor is part and parcel of the legislature of a state which consists for the governor and the house or houses of legislature, as the case may be. Article 168. The governor nominates 1/6 of the total number of the members of the upper house of Legislative Council where such council exists. The governor makes nominations of persons having special knowledge or experience in literature, science, art, cooperative movement and social service, Article 171. He may nominate two members of the Anglo-Indian community for a period of 10 years from the commencement of the Constitution if he is of opinion that the community is not adequately represented in the State Assembly. Article 333. The Governor summons, prorogues the Houses of the Legislature, and dissolves the Legislative Assembly. Article 174. He addresses the Houses of the Legislature. Articles 175, 176. He gives assent to bills without which no bill can become law. Article 200. He sends messages to the legislature. Article 176. The governor is empowered to make rules for the more convenient transaction of the business of the government of the state, and for the allocation among ministers of the said business in so far as it is not business with respect to which the governor is by or under the Constitution required to act in his discretion. Article 166. He appoints the Advocate General of the state. Article 165. The chairman and members of the State Public Service Commission. Article 316. And the judges of subordinate judiciary in consultation with the State High Court. Article 283, 284. 3. Ordinance-making power of the governor. The most important power of the governor is a power to promulgate ordinances under Article 213. His power in this respect are similar to those of the President. Ordinances are promulgated when the legislature is not in session and the matters to which the ordinance relates require an immediate action in this respect. There are certain ordinances which cannot be promulgated without instructions from the President. Such an instruction is required of a bill containing the same provisions as the ordinance would. I have required the previous sanction of the President, or 2 have been reserved by the governor for the consideration of the President, or 3 have required the assent of the President before it becomes law. Article 213. 4. Financial powers and functions. No money bill or other financial bill can be introduced, and no demand for grants may be moved in the legislature except on the recommendation of the governor. The governor causes the annual financial statement, that is, the budget is laid before the House or Houses of Legislature, and is authorized also to place demands for supplementary and additional grant if required in any year. The governor has the contingency fund of the state at his disposal for emergencies. Subject to limits, if any, fixed by the legislature, the governor can borrow money on the security of the consolidated fund of the state and guarantee the loans of any other local authorities. Articles 205, 207 and 209. 5. Power to grant pardon, etc. The Article 161 provides that the governor of a state shall have the power to grant pardons, reprieves, respites or remissions of punishment, or to suspend, remit or commute the sentence of any person convicted of any offense against any law relating to a matter of which the executive power of the state extends. In K.M. Nanavati v. State of Bombay, AIR 1961 SC 99, the Supreme Court held that the power of the governor to suspend sentences under Article 161 is subject to the rules made by the Supreme Court with respect to only those cases which are pending before it in appeal. It is open to the governor to grant a full pardon at any time even during the pendency of the case in the Supreme Court, but the governor cannot exercise his power of suspension of the sentence for the period when the Supreme Court is seized of the case. Position of governor. Like the President of India, the governor is also a mere constitutional head. Though all the above-mentioned powers are vested in him, but he is required to exercise his powers with the aid and advice of his Council of Ministers. In Ram Javaya Kapoor v. State of Punjab, AIR 1955 SC 549, the Supreme Court has held that the President and the Governor in India are only constitutional heads. The real executive power is exercised by the Council of Ministers. The President and the Governor are required to exercise their powers on the advice of the Council of Ministers. In Shamsher Singh v. State of Punjab, AIR 1974 SC 2193, the Supreme Court held that wherever the Constitution requires the satisfaction of the Governor, the satisfaction is the satisfaction of the Council of Ministers and not the personal satisfaction of the Governor. He is merely a constitutional head. Accordingly, it was held that the removal of the members of the subordinate judiciary by the concerned minister was valid. Under Article 155, the Governor holds office during the pleasure of the President and continues to hold this office at the discretion of the President. In this respect, he occupies the position of a representative of the Union in the state. However, Article 163(1) states that there shall be a Council of Ministers with Chief Minister at the head to aid and advise the Governor in the exercise of his functions or any of them in his discretion. Article 239(2) also states that where a Governor is appointed an administrator, he shall exercise his functions as such administrator independently of his Council of Ministers. Besides, a reference may be made to Articles 356 and 200. In making reports to the Union, the Governor will be justified in exercising his discretion even against the aid and advice of the Council of Ministers. The reason is that the failure of the constitutional machinery may be because of the conduct of the Council of Ministers. Similarly, Article 200 indicates another instance where the Governor may act in reserving a bill for consideration of the President irrespective of the advice of Council of Ministers. In such matter, the Governor has to discharge his duties to the last of his judgment and pursue such cause which is not detrimental to the state. As mentioned above, in certain matters the Governor is required by or under this Constitution to act in his discretion. In this respect, Governor may be regarded as a link between the Union and the states, thereby providing an opportunity to the Union to have some kind of control over the states. As such, the Governor may be regarded as a representative of the Union in the states. Q. 53 discuss the relationship of Governor of the state with the Council of Ministers in that state. Or, is Governor bound to act with the advice of his minister? Does the Constitution confer discretionary power upon the Governor, and if so, what are such powers? Ans. The Governor is a constitutional head in a state like the President in the center. The executive power of the state is vested in him, and such power is to be exercised by him directly or through officers subordinate to him in accordance with the Constitution. Article 114. There is a Council of Ministers with the Chief Minister at the head to aid and advise the Governor in the exercise of his functions except in matters where the Governor is by, or under the Constitution, required to act in his discretion. The Governor appoints the Chief Minister, and other ministers are appointed by the Governor on the advice of the Chief Minister. All ministers hold office during the pleasure of the Governor. The Council of Ministers is collectively responsible to the Legislative Assembly of the state and may be removed from office by an adverse vote therein. Although the Chief Minister is appointed by the Governor, but the Governor has no discretion in this matter. He is bound to appoint the leader of the majority party as the Chief Minister. It is only when no party secures majority in the legislature the Governor can exercise his discretion in the selection of the Chief Minister. The ministers cannot be dismissed by him at his discretion. The ministry is responsible to the Legislative Assembly and therefore, so long as they enjoy the confidence of the majority, they cannot be dismissed. The Council of Ministers act as a team and responsible to the legislature and not to the governor. All decisions are taken by the Council of Ministers. These decisions are conveyed to the governor by the Prime Minister. All these provisions make it clear that the governor is a mere constitutional head and acts through a body responsible to the people. Normally, the governor is bound to act with the advice of his Council of Ministers in all matters except where he is required to act in his discretion. In Sunil Kumar v. Government of West Bengal, AIR 1950 calories. To 74, the Calcutta High Court observed, the governor under the present constitution cannot act except in accordance with the advice of his ministers. The only functions which the governor may be called upon in certain circumstances to exercise in his personal discretion are the following. 1. Appointment of the Chief Minister. 2. Dismissal of a ministry. 3. Dissolution of the Legislative Assembly. 4. Under Paras 9 and 18 of 6th Schedule in respect of tribal areas in Assam. 5. In advising the President to impose President rule in states. 1. Appointment of the Chief Minister. In normal circumstances, he has no discretion in this matter. He is bound to appoint the leader of the majority party as the Chief Minister. But when no party secures a clear majority in the House, the governor may exercise his discretion in this matter. 2. Dismissal of a minister. The ministers hold office during the pleasure of the governor. This means that a ministry can be dismissed by the governor. But so long as a ministry enjoys the support of the majority in the legislature, the governor cannot dismiss it. However, if a ministry loses the majority support in the House or a non-confidence motion is passed against it, the governor may dismiss such a ministry. Whether a ministry has lost the majority or not must be decided on the floor of the House. 3. Dismissal of Legislative Assembly. Normally the Assembly will be dissolved by the governor on the advice of the Cabinet. But when the Chief Minister has lost the majority in the House and advises the governor to dissolve the Assembly, the governor may refuse to do so. He may take his own decision in this matter. 4. Under Para 16, 2 of 6th Schedule in respect of tribal areas of Assam. In this respect, the Constitution expressly provides that in certain circumstances the governor might act in his discretion. This is confined to tribal areas of Assam only. 5. In advising the President to impose President rule in states. In this matter, the governor is not required to consult his cabinet. The governor takes his own decision whether there are circumstances justifying that government of the state cannot be carried on in accordance with the provisions of the Constitution. He may then report the matter to the President for appropriate actions under the Constitution. Q. 54 describe the composition of A. Legislative Assembly, Vidhan Sabha. B. Legislative Council, Vidhan Parishad. Ans. 1. Legislative Council. The Legislative Council is the upper house of State Legislature. The total number of members of Legislative Council shall not exceed 1/3 of the total number of members of Legislative Assembly, provided that total numbers in Legislative Council of the state shall in no case be less than 40. Until the Parliament by law otherwise provides, composition of Legislative Council of the state shall be as provided in Clause 3 of Article 17. The total number of members of the Legislative Council of the state will be as follow. A. As nearly as may be, 1/3 shall be elected by electorates consisting to the members of municipalities, district boards, and such as local authorities in the state as Parliament may by law specify. B. As nearly as may be, 1/12 shall be elected by electorates consisting of persons residing in the state who have been for at least 3 years graduates of any university in the territory of India, or have been for at least 3 years in possession of qualification prescribed by or under any law made by Parliament to that of graduate of any such university. C. As nearly as may be, 1/12 shall be elected by electorates consisting of persons who have been at least 3 years engaged in teaching in such educational institutions within the state, not lower in standard than that of a secondary school, as may be prescribed by or under any law made by Parliament. D. As nearly as may be, 1/3 shall be elected by the members of the Legislative Assembly of the state from amongst persons who are not members of the Assembly. E. The remainder shall be nominated by the Governor in accordance with the provisions of Clause 5. The members to be elected under subclauses A, B, and C of Clause 3 shall be chosen in such territorial constituencies as may be prescribed by or under any law made by Parliament, and the elections under the said subclauses and under subclause D of the said clause shall be held in accordance with the system of proportional representation by means of the single transferable vote. The members to be nominated by the Governor under subclause E of Clause 3 shall consist of persons having special knowledge or practical experience in respect of such matters as the following, namely literature, science, art, cooperative movement, and social service. Duration of Legislative Council. The Legislative Council is not subject to dissolution, but as nearly as 1/3 of its members shall retire at the end of every second year. Like Council of States, it is also a permanent house. 2. Legislative Assembly, Vidhan Sabha. The Legislative Assembly in a state is popular house. The minimum number of seats of the Legislative Assembly is fixed at 60 and the maximum number is fixed at 500. The members of Legislative Assembly are chosen directly by the people on the basis of adult franchise from territorial constituencies in the state. Article 171. The representation in the House is on basis of population in respect of each territorial constituency in the state. The 42nd Amendment had amended Article 170 and added a new explanation, which provided that the number of seats in state assemblies would be determined on the basis of the 1971 census and would be frozen till the year 2000. The Constitution, 84th Amendment, Act 2001 has substituted for the figures 2000 the figures 2026. The expression population for this purpose means the population as determined on the basis of 1991 census. The redetermination of the constituencies on the basis of new census undertaken after the year 2026 will take effect on dates fixed by the President. In the Legislative Assembly of every state, seats will be reserved for the scheduled tribes and scheduled castes on the basis of population. Article 332. Its tenure. The normal tenure of the Legislative Assembly of every state is of 5 years, but it may be dissolved earlier by the Governor. Article 172. During the proclamation of emergency, the life of the Assembly may be extended by an Act of Parliament for a period of 1 year at a time, but in no case beyond a period of 6 months after the proclamation has ceased to operate. Article 172. Qualification of membership. A person to be qualified to be chosen as a member in the state legislature A. Must be a citizen of India and makes and subscribes before some persons authorized by the Election Commission an oath or affirmation prescribed in the third schedule. B. Must not be less than 25 years of age in the case of the Legislative Assembly and not less than 30 years in case of the Legislative Council. C. Must possess much other qualification as may be prescribed by Parliament by law. Article 173. Disqualification of membership. A person is disqualified for being chosen as a member of the legislature of a state. A. If he holds any office of profit under the central or state government, or B. If he is of unsound mind. C. If he is an undischarged insolvent. D. If he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance or adherence of a foreign state. E. If he is so disqualified by or under any law of Parliament. Article 191. Article 19 deals with the disqualifications incurred by a member after he has been elected as member. It says that no one can be a member of both the houses of the legislature of a state or a member of the legislature of two or more states at the same time. If a person is chosen a member of the legislature of two or more states, then at the expiry of the specified period under rules made by President, his seat in the legislature shall fall vacant unless he resigns his seat in all but one of the states. If a member of state legislature absents himself without the permission of the House from all meetings for a period of 60 days, excluding the period for which the House is prorogued or is adjourned for more than 4 consecutive days, the House may declare his seat vacant. Article 193(4). If a member becomes disqualified under CL 1 of Article 191, his seat shall become vacant. Q. 55 describe the legislative procedure in state legislature. Ans. I. Procedure for ordinary bills. Article 196 of the Constitution provides provision as to introduction and passing of ordinary bills. It lays down 1. Subject to the provisions of Article 198 and 207 with respect to money bills and other financial bills, a bill may originate in either house of state legislature having legislative council. 2. Subject to the provisions of Article 1987 and 198, a bill shall not be deemed to have been passed by the houses of the legislature of a state having a legislative council unless it has been agreed to by both houses, either without amendment or with such amendments only as are agreed to by both houses. According to Article 197, 1. If a bill has been passed by the Legislative Assembly of a state having a legislative council and transmitted to the Legislative Council. A. The bill is rejected by the council, or B. More than 3 months elapsed from the date on which the bill is laid before the council without the bill being passed by it, or C. The bill is passed by the council with amendments to which the Legislative Assembly does not agree. The Legislative Assembly may, subject to the rules regulating its procedure, pass the bill again in the same or in any subsequent session with or without such amendments, if any, as have been made, suggested or agreed to by the Legislative Council, and then transmit the bill as so passed to the Legislative Council. Article 197, 2, provides that if a bill has been so passed for the second time by the Legislative Assembly and transmitted to the Legislative Council, A. The bill is rejected by the Council, or B. more than 1 month elapses from the date on which the bill is laid before the Council without the bill being passed by it, or C. The bill is passed by the Council with amendments to which the Legislative Assembly does not agree. The bill shall be deemed to have been passed by the Houses of the Legislature of the state in the form in which it was passed by the Legislative Assembly for the second time with an amendments, if any, as has been made or suggested by the Legislative Council and agreed to by the Legislative Assembly. Money bills. A money bill must originate in the lower houses of the state legislature, Legislative Assembly. A money bill cannot originate in the Legislative Council. After a money bill has been passed by the Legislative Assembly, it shall be transmitted to the Legislative Council for its recommendations. The Legislative Council must return the bill to the Legislative Assembly with its recommendations within a period of 14 days from the date of its receipt of the bill. The Legislative Assembly may either accept or reject all or any of the recommendations of the Legislative Council. If the Legislative Assembly accept any of the recommendations of the Legislative Council, the money bill shall be deemed to have been passed by both houses, with the amendments recommended by the Legislative Council and accepted by the Legislative Assembly. If the Legislative Assembly rejects all the recommendations of the Council, the money bill shall be deemed to have been passed by both houses in the form in which it was passed by the Legislative Assembly. But if a bill is not returned by the Council within 14 days, it shall be deemed to have been passed by both houses at the expiration of such period in the form in which it was originally passed by the Legislative Assembly. Articles 198 and 199. Assent to bills. Article 200. When a bill has been passed by both the houses, the bill is sent to Governor for his assent. He may declare either that A. He assents to the bill, B. He withholds his assent, C. He reserves the bill for the consideration of the President. At least in one case, where a bill is likely to affect the powers of the High Court of a state, the Governor must reserve it for the consideration of the President. D. He may return the bill to the Houses for reconsideration. In the last case, when a bill, returned by the Governor for the reconsideration of the Houses, is passed again by the Houses with or without amendments and presented to the Governor for assent, the Governor shall not withhold assent second time. This means that he cannot reject the bill. He must give his assent or reserve the bill for the consideration of the President. Bills reserved for President's consideration. Article 201. Under Article 201, the Governor may reserve certain bills passed by the State Legislature for the consideration of the President. When a bill is reserved by a Governor for the consideration of the President may take one of the three courses. 1. He assents to the bill. 2. He withholds his assent to the bill, or 3. He may, where the bill is not a money bill, direct the Governor to return the bill to the Houses of the State Legislature together his suggestions, as referred to in the first proviso to Article 200. It shall be the duty of the Legislature to reconsider the bill within a period of 6 months. If it is again passed by the Houses, it shall be presented to the President for his consideration. Procedure in financial matters. Articles 20 to 207. In financial matters, the procedure in the state is similar to that in Union. The procedure for the submission of the annual financial statement, or the passing of the Annual Appropriation Act, votes of credit, votes on accounts, and supplementary grants, etc., is analogous to that in the Union under Article 112. General rules of procedure, as in the case of the center. A house of the legislature of a state has right to make rules for regulating its procedure and conduct of his business. These rules are subject to the provisions of the Constitution, Article 208. The validity of any proceedings in the legislature shall not be called in question on the grounds of alleged irregularity of the procedure, Article 212. Q. 56 discuss about the constitution of the High Court. How are the judges appointed and what are their qualifications? In what manner they may be removed from the office? Ans. Article 214 says that there shall be a High Court in each state. However, under Article 231, 1. Parliament can establish by law a common High Court for 2 or more states or for 2 or more states and a union territory. The High Court stands at the head of the judiciary in the state. Constitution of High Courts. Every High Court consists of a Chief Justice and such other judges as the President may, from time to time, deem it necessary to appoint, Article 216. Thus the Constitution does not fix any maximum number of judges of a High Court. Appointment of judges. Article 217 provides that every judge of a High Court shall be appointed by the President. The President appoints the Chief Justice of a High Court after consultation with the Chief Justice of India and the Governor of the state concerned. In case of appointment of a judge other than the Chief Justice, he may consult even the Chief Justice of the High Court concerned. In S.P. Gupta and others v. Union of India, AIR 1982 SC 149, popularly known as the Judges Transfer Case, the question was whether in appointing the additional judges of the High Courts the President was bound by the advice of the Chief Justice of India. Under Article 217, the President is obliged to consult the 3 functionaries, the Chief Justice of India, the Chief Justice of High Court, and the Governor of the state. In this context, the majority held that the opinion of the CJ of India had no primacy over the opinion of the Chief Justice of the High Court under Article 217. According to Bhagwati, J., all the 3 functionaries, Chief Justice of High Court, Chief Justice of India, and the Governor of a state are given equal importance in the consultation process, and there is no superiority over the opinion of one over that of another. In a historic judgment, SC Advocate on Record B, Union of India, 1993, 4 SCC 441, a 9-judge bench of the Supreme Court by a 7-2 majority overruled the judges' transfer case and held that in matter of appointment and transfer of judges greatest significance should be attached to the view of the Chief Justice of India. The majority gave primacy to the opinion of the Chief Justice of India formed in consultation with the senior-most judges of the Supreme Court in regard to appointment and their transfers. The court held that the process of appointment must be initiated by the Chief Justice of the High Court. In the event of conflicting opinion by the constitutional functionaries, the opinion of the judiciary symbolized by the view of the Chief Justice of India, formed after consulting some of his colleagues, has primacy. In pre-presidential reference, AIR 1999 SC1, known as Appointment and Transfer of Judges case, a 9-member bench of the Supreme Court has unanimously held that recommendations made by the Chief Justice of India on the appointment of judges of the Supreme Court and High Courts without following the consultation process are not binding on the government. The court has widened the scope of Chief Justice of India's consultation and held that the consultation process to be adopted by the CJI under Articles 217, 1 and 222, 1 requires consultation of plurality of judges. The sole opinion of CJI does not constitute consultation process. The court held recommendations made by the CJI without complying with the norms and guidelines regarding the consultation process are not binding on the government. In regard to the appointment of judges of the high courts, the court held that the CJI should consult a collegium of two senior-most judges of the Supreme Court. Transfer of a judge from one high court to another. Article 222(1) empowers the President after consultation with the Chief Justice of India to transfer a judge from one high court to any other high court. Clause 2 makes provisions for the grant of compensatory allowance to a judge who goes on transfer to another high court. In Union of India v. Sankalchan, AR 1977 SC 2328, the constitutionality of a notification issued by the President by which Justice Sankalchan Sheth of the Gujarat High Court was transferred to the High Court of Andhra Pradesh was challenged on the ground that the order was passed without the consent of the judge and against public interest and without effective consultation of the Chief Justice of India. The Supreme Court held that a judge of a high court could be transferred under Article 222(1) without his consent. If consent was imported in Article 222 so as to make condition precedent to transfer a judge from one high court to another than a judge by withholding consent could render the power contained in Article 222 wholly ineffective and nugatory. The power to transfer a high court judge is conferred by the Constitution in public interest and not for the purpose of providing the executive with a weapon to punish a judge who does not touch its line or who, for some reason or the other, has fallen from its grace. Qualifications: a person to be qualified for appointment as judge of a high court. A. Must be a citizen of India. B. Must have held a judicial office for at least 10 years in the territory of India. C. Must have been an advocate of High Court for at least 10 years. R. 217, 1 and 2. Term and removal of judges. A judge of the High Court shall hold office until he attains the age of 62 years. If a question arises as to the age of a judge of a High Court, then it shall be decided by the President after consultation with the Chief Justice of India, and the decision of the President shall be final. Article 217(3). A judge may, however, be removed from the office by the President in the same manner and on the same grounds as a judge of the Supreme Court. The office of a judge falls vacant by his being appointed by President to be judge of the Supreme Court or being transferred to any other high court. A judge may also resign his office by writing to the President. Article 220. Q 57 describe the jurisdiction and powers of the high courts. Ans. Jurisdiction of high courts. The Constitution does not make any detailed provisions regarding the general jurisdiction of the high courts. Under Article 225, the jurisdiction of the high courts, the law administered by them, the respective powers of their judges in relation to the administration of justice by the court, and their rule-making power, all are to be the same as were enjoyed by them immediately before the commencement of the Constitution. The Constitution thus maintains the status quo existing on the eve of the commencement of the Constitution in relation to the jurisdiction and powers of the high courts. The status quo is, however, subject to the provisions of the Constitution and to any law made by the appropriate legislature in pursuance of its powers under the Constitution. The proviso to Article 225 lays down that any restriction on the original jurisdiction of a high court regarding a revenue matter, or an act ordered or done in revenue collection, existing prior to the commencement of the Constitution, will no longer exist. The second important change affected by the Constitution in the jurisdiction of high courts is through the all-important Article 226, which empowers the high courts to issue the writs. This is an important power to enforce the rights of the people, to administer justice, and to review administrative action. According to Article 226(1) of the Constitution, it may be issued to any person, authority including in appropriate cases, any government within those territories, directions, orders or writs like habeas corpus, mandamus, certiorari, covenanto, prohibition, or any of them for the enforcement of fundamental rights conferred on the people in Part 3 of the Constitution. It may be pointed out that remedy under Article 226 is discretionary and the court may refuse to grant the remedy under Article 226 if adequate remedy is available to the petitioner. But in Himmat Lal v. State of UP, AIR 1954 SC 403, however, the Supreme Court has held that the existence of an alternate remedy is no bar to the exercise of writ jurisdiction where there is violation of fundamental rights. Power of superintendence. According to Article 227, every high court shall have superintendence over all courts and tribunals throughout the territories of India in relation to which it exercises jurisdiction, except any court or tribunal constituted by or under any law relating to the armed forces. The power of superintendence under Article 227 is of an administrative as well as judicial nature. This power, being an extraordinary one, is to be sparingly exercised and in appropriate cases to keep the subordinate courts within the bounds of their authority and jurisdiction and not for correcting mere errors. Control over subordinate courts. Article 235 vests in High Court the control over the subordinate courts. While Article 227 deals with the official acts of the persons occupying those courts, Article 235 deals with subordinate judicial officers themselves in relation to their discipline, posting and promotions. Further, Article 227 deals with both the courts and tribunals, but Article 235 deals with the controlling power of the High Court only with the courts, not with tribunals. Court of Record. According to Article 215, every high court shall be a court of record and shall have power to punish for its contempt by itself. General jurisdiction. Under other statutes, high courts have original and appellate jurisdiction in civil and criminal matters as conferred by other statutes and their letter patents. Such powers have been safeguarded by Article 225 of the Constitution in favor of the high courts. Q. 58. What do you understand by union territories? Ans. The union territories are formed by centrally administered areas. Article 239 of Constitution of India makes the specific provisions for administration of union territories. Article 239 provides that a union territory is to be administered by the President acting to such extent as he thinks fit through an administrator to be appointed by him with such designation as he may specify. Article 239(2) says a governor of a state may also be appointed by him as the administrator of an adjoining union territory. Where a governor is so appointed as administrator for the union territory, he shall exercise his functions as such administrator independently of his council of ministers. Article 239 of Constitution empowers the Parliament to create by law for Union Territory of Pondicherry, a legislature or a council of ministers. Such legislature may be an elected nominated or partly nominated partly elected. Under Article 239-B, Administrator of Union Territory of Pondicherry is empowered to promulgate ordinances when the legislature is not in session. However, no such ordinance can be promulgated without prior permission of President. The Constitution, 69th Amendment, Act 1992, had added two new articles I. Article 23A and Article 239 up to the Constitution, which gave special status to the Union Territory of Delhi. Article 239A provides that the Union Territory of Delhi shall now be called as National Capital Territory of Delhi, and the administrator appointed under Article 239 shall be designated as Lieutenant Governor. Article 239A provides that if the President of India, on the report of Lieutenant Governor or otherwise insatisfied, that a situation has arisen in which the administration of nation capital territory cannot be carried or in accordance with provisions of Article 239 or any law made in pursuance of that article, or b. that for the proper administrator of national capital territory is necessary or expedient to do so, the President may by order suspend the operation of any provision of Article 239 or all or any of the provisions, if any made in pursuance of that article for such period and subject to such condition as may be specified in such incidental and consequential provisions as may appear to him to necessary and expedient for administering the national capital territory in accordance with provisions of Article 239 and 239A. According to Article 240, the President is empowered to make regulations for peace, progress and good government of the Union Territory of Andaman and Nicobar Island, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu and Pondicherry. Article 241 empowers Parliament by law to constitute a High Court for Union Territory or declare any court in any such territory to be a High Court for all or any of the purposes of the Constitution. Q. 59 discuss the composition, reservation, duration, power and responsibilities of Panchayats according to provisions of the Constitution. Ans. The Constitution, 73rd Amendment, Act 1992 added a new Part 9 consisting of 16 articles and the 11th schedule to the Constitution. The 73rd Amendment Act envisages the Gram Sabha as the foundation of the Panchayati Raj system to perform functions and powers entrusted to it by the state legislatures. Gram Sabha Article 243 provides that the Gram Sabha may exercise such powers and perform such functions at the village level as the legislature of a state may by law provide. The 73rd Amendment thus envisages the Gram Sabha as the foundation of Panchayati Raj system. Gram Sabha means a body consisting of persons registered in the electoral rolls relating to a village comprised within the area of Panchayat at the village level. Constitution of Panchayats Article 243b visualizes a three-tier Panchayati Raj system. It provides that in every state there shall be constituted Panchayats at the village, intermediate and district levels. Small states having a population not exceeding 20 lakhs have been given an option not to constitute the Panchayats at the intermediate level. Composition of Panchayats Article 243c provides that, subject to the provisions of this part, the legislature of a state may by law make provisions with respect to the composition of Panchayats. However, the ratio between the population of the territorial area of a Panchayat at any level and the number of seats in such Panchayats to be filled by election shall, so far as practicable, be the same throughout the state. All the seats in a panchayat shall be filled by the persons chosen by direct election from territorial constituencies in the panchayat area. For this purpose, each panchayat's area shall be divided into territorial constituencies in such manner that the ratio between the population of each constituencies and the number of seats allotted to it, so far as practicable, be the same throughout the panchayat area. Clause 2. The legislature of a state may by law provide for representation of following persons in panchayats. A. The chairpersons, chairmen, of the panchayats at the village level, in the panchayats at the intermediate level, or in the case of a state not having panchayats at the intermediate level, in the panchayats in the district level. B. The chairpersons of the panchayats at the intermediate level, in the panchayats at the district level. C. The members of the Lok Sabha and the Legislative Assembly of the state representing constituencies which comprise wholly or partly a panchayat area at the level other than the village level, in such panchayats. D. The members of the Rajya Sabha and Legislative Council of the state where they are registered as electors. I. A panchayat area at the intermediate level, in panchayat at the intermediate level. 2. A panchayat area at the district level, in panchayat at the district level. The chairpersons of a panchayat and other members of a panchayat, whether or not chosen by direct election from territorial constituencies in the panchayat area, shall have the right to vote in the meetings of panchayat. Article 243, 4. The chairperson of a panchayat at the village level shall be elected in such a manner as the legislature of a state may by law provide. The chairpersons of a panchayat at the intermediate level or district level shall be elected by and amongst the elected members thereof. Article 243, 5. Disqualifications for membership. A person shall be disqualified for being chosen as and for being a member of panchayats. A. If he is so disqualified by or under any law for the time being in force for the purposes of elections to the legislature of the state concerned. B. If he is so disqualified by or under any law made by the legislature of the state. But no person shall be qualified on the ground that he is less than 25 years of age under clause A. If he has attained the age of 21 years. If any question arises as to whether a member of a panchayat has become subject to any of the qualifications mentioned in clause 1, the question shall be referred for the decision of such authority and in such manner as the legislature of a state may, by law, provide. CL.2. Reservation of seats in panchayats. Article 243d provides that in every panchayat seats shall be reserved for the scheduled castes and scheduled tribes. The number of seats so reserved shall be, as nearly as may be, in the same proportion to the total number of seats to be filled by direct election in that panchayat as the population of the SCs and CENs in that panchayat area bears to the total population of that area, and such seats may be allotted by rotation to different constituencies in a panchayat. Out of total number of seats reserved under clause 1, not less than 1/3 seats shall be reserved for women belonging to the SCs and CENs. Clause 2. Out of total number of seats to be filled by direct election in every panchayat, not less than 1/3, including the number of seats reserved for SCs and CENs women, seats shall be reserved for women. Such seats may be allotted by rotation to different constituencies in a panchayat. Clause 3. Duration of panchayats. According to Article 243e, every panchayat, unless sooner dissolved under any law for the time being in force, shall continue for 5 years from the date appointed for its first meeting. No amendment of any law in force shall have effect of causing dissolution of a panchayat at any level which is functioning before such amendment till the expiration of its normal period of 5 years. Clause 2. An election to constitute a panchayat must be completed. A. Before the expiry of its duration. B. Before the expiration of a period of 6 months from the date of its dissolution. Clause 3. Powers, authority and responsibility of Panchayat. Article 243G provides that subject to the provisions of this constitution the legislature of a state may, by law, endow the Panchayats with such powers and authority as may be necessary to enable them to function as an institution of self-government. Such law may contain provisions for the devolution of powers and responsibilities upon panchayats subject to such conditions as may be specified therein, with respect to A. The preparation of plans for economic development and social justice. B. The implementation of schemes for social development and social justice as may be entrusted to them, including those in relation to the matters listed in the 11th schedule. Powers to impose taxes and funds of Panchayats. Article 243H empowers a state legislature to make by law provision for imposing taxes, etc. by the Panchayats. Such a law A. Authorize a Panchayat to levy, collect and appropriate such taxes, duties, tolls and fees in accordance with such procedure and subject to such limits. B. Assign to a Panchayat such taxes, duties, tolls and fees levied and collected by the state government for such purposes and subject to such conditions and limits. C. Provide for making such grants in aid to the Panchayats from the consolidated fund for the state, and D. Provide for constitution of such funds for crediting all monies received by or on behalf of the Panchayats and also for the withdrawal of such money therefrom. Q. 60 discuss the composition, reservation, duration, powers and responsibilities of municipalities according to the provisions of Constitution. Ans. Part 9A was added to the Constitution by the Constitution, 73rd Amendment, Act, 1992. Constitution of Municipalities. Article 243Q provides for the establishment of the following 3 types of municipal corporations for urban areas. A. A Nagar Panchayat for a transitional area, that is to say, an area is transitioned from a rural area to a urban area. B. A municipal council for smaller urban area, and C. A municipal corporation for a larger urban area. Composition of municipalities. Article 243A provides that save as provided in Clause 2, all the seats in a municipality shall be filled by persons chosen by direct elections from territorial constituencies in the municipal area. For this purpose, each municipal area shall be divided into territorial constituencies to be known as wards. The legislature of a state may by law provide for the representation in a municipality of the following. I. Persons having special knowledge or experience to municipal administration. 2. The members of the Lok Sabha and the Legislature Assembly of the state representing constituencies which comprise wholly or partly the municipal area. 3. The members of the Rajya Sabha and the Legislative Council of the state registered as electors within the municipal area. 4. The chairpersons of the committees constituted under Clause 5 of Article 243S. However, the persons referred to in paragraph I shall not have the right to vote in the meeting of the municipality. The legislature will also by law provide the manner of election of the chairpersons of a municipality. A municipal area under Article 243-R means the territorial area of a municipality as is notified by the governor. Reservation of seats in municipalities. Article 243-T provides for the reservation of seats for the members of scheduled castes and scheduled tribes in every municipality. The number of seats reserved for them shall be as nearly as may be, in same proportion to the total number of seats to be filled by directed election in that municipality as the population of the SCs and CENs in the municipal area bears to the total population of that area, and such seats may be allotted by rotation to different constituencies in a municipality. Out of total number of seats reserved under Clause 1, 1/3 seats shall be reserved for women belonging to the SCs and CENs, as the case may be. Out of total number of seats, including the number of seats reserved for women belonging to the SCs and CENs, to be filled by direct election in every municipality, 1/3 seats shall be reserved for women. Such seats may be allotted by rotation to different constituencies in a municipality. Clause 2 and 3. The office of chairpersons in the municipalities shall be reserved for the SCs, CENs and women in such manner as the legislature of a state may, by law, provide. Article 243-T, 4. Reservation of seats for backward class of citizens under Clause 6. The legislature is empowered to make provisions for reservations of seats in any municipality of office chairpersons in the municipalities in favor of backward class of citizens. All kinds of reservation of seats shall cease to have effect on the expiration of the period specified in Article 334, that is, up to 50 years from the commencement of the Constitution. Duration of municipalities. Article 243U provides that every municipality, unless sooner dissolved under any law for the time being in force, shall continue for 5 years from the date appointed for its first meeting. An election to constitute a municipality shall be completed before the expiration of its duration and before the expiration of a period of 6 months from the date of its dissolution in case it had been dissolved earlier. But where the remainder of the period for which the dissolved municipality would have continued is less than 6 months, it shall not be necessary to hold elections under this clause for constituting the municipality for such period. Clause 3. Disqualifications for membership. According to Article 243V, a person shall be disqualified for being chosen as, and for being, a member of a municipality. A. If he is so disqualified by or under any law for the time being in force for the purposes of elections to the legislature of the state concerned. B. If he is so disqualified by or under any law made by the legislature of the state. However, a person shall not be disqualified on the ground that he is less than 25 years of age, if he has attained the age of 21 years. Thus, a person having attained the age of 21 years is eligible for being chosen as a member of a municipality. Powers, authority and responsibilities of municipalities under Article 243W. The legislature of a state, subject to the provisions of this Constitution, is empowered by law to endow A. The municipalities with such powers and authority as may be necessary to enable them to function as institution of self-government, and such law may contain provisions for the devolution of powers and responsibilities upon municipalities, subject to such conditions as may be specified therein, with respect to I. The preparation of plans for economic development and social justice. 2. The performance of functions and the implementation of schemes as may be entrusted to them, including those in relation to the matters listed in the 12th schedule. B. The committees with such powers and authority as may be necessary to enable them to carry out the responsibilities conferred upon them, including those in relation to the matters listed in the 12th schedule. Q. 61. Discuss how the legislative powers between the Union and the states are distributed under the Constitution. What do you mean by 1. Union list, 2. State list and 3. Concurrent list? Ans. The distribution of powers is an essential feature of federalism. The object for which a federal state is formed involves a division of authority between the national government and the separate states. The Constitution of India makes twofold distribution of legislative powers. 1. With respect to territory. 2. With respect to subject matter. Territorial jurisdiction. Article 245, 1, provides that subject to the provisions of this Constitution, Parliament may make laws for the whole or any part of the territory of India. According to Clause 2 of Article 245, a law made by Parliament shall not be deemed to be invalid on the ground that it has extraterritorial operation, i.e. takes effect outside the territory of India. In H. Wadia v. Income Tax Commissioner, Bombay, AIR 1949 FC 18, the Supreme Court held, in the case of a sovereign legislature, question of extraterritoriality of any enactment can never be raised in the municipal court as a ground for challenging its validity. The legislature of a state may make laws for the whole or any part of the state. Article 245, 1. This means that state laws would be void if it has extraterritorial operation, i.e., takes effect outside the state. Hence, state law would be invalid if it has extraterritorial operation, i.e., takes effect outside the state. But there is exception to this general rule. A state law of extraterritorial operation will be valid if there is sufficient nexus between the object and the state. State of Bombay v. R.M.D.C. AIR 1957 SC 699. 2. Jurisdiction with respect to subject matter. A federal system postulates a distribution of powers between center and states. The nature of distribution varies with the local circumstances of each country. In America, Australia, Canada and other federal countries, the government powers are clearly demarcated by their constitutions. The American Constitution only enumerates the powers of the central government and leaves the residuary powers to the states. Australia follows the American pattern and enumerates only the powers of the central government. In Canada, there is double enumeration of federal and provincial, leaving the residue for the centre. Canada opted for a strong centre. The Indian Constitution has followed the Constitution of Canada, obviously option for a strong centre. However, they added one list, the concurrent list. The present Constitution divides the powers between the Union and the states in three lists: the Union list, List I, the State list, List 2, and the concurrent list, List 3. The powers not enumerated in three lists, that is residuary powers, are entrusted to the centre. 1. Union list. The Union list comprises subjects within the legislative competence of the Parliament. The State list subjects within the legislative competence of the state. The concurrent list, subjects in respect of which both the union and state have jurisdiction to legislate. The union list includes 97 items including defense, foreign affairs, banking, currency, and coinage, etc. 2. State list. The state list includes 66 items including public order and police, local government, public health and sanitation, agriculture, forest, fisheries, education and state taxes, etc. The 42nd Amendment has taken out education from it and included it in concurrent list. 3. Concurrent list. The concurrent list consists of 47 items such as criminal law and procedure, civil procedure, marriage, contracts, torts, trusts, welfare of labor, social insurance, economic and social planning. Where a law of the state is repugnant to a law of the union, the latter shall prevail. In respect of a subject, in concurrent list the state law may prevail notwithstanding repugnancy, if the state law reserved for the assent of the President and has received such assent. Residual powers. Parliament has exclusive power to legislate with respect to any matter not included in the concurrent or state list, Article 248. Such exclusive powers are called residuary powers. Entry 97 in the Union list also lays down that the Parliament has the exclusive powers to make laws with respect to any of the matters not stated in the three lists. Unlike the Constitution of India, the Constitution of the USA, Australia and Switzerland vest the residuary power not in the centre but in the states. In the state of Karnataka v. Union of India, AIR 1978 SC 68, the Supreme Court observed that if the subject of enquiries the ministers in the state government is not mentioned specifically either in any of the articles of the Constitution or in the legislative lists, it does not follow from it that legislation covering such enquiries is incompetent except by means of Constitution amendment. On the contrary, under Article 248 also Parliament has exclusive power to make law on any matter including levy of tax not enumerated in the state list or concurrent list. Q. 60 to discuss under what circumstances the Parliament can legislate on state list. Ans. Though in normal times the distribution of powers must be strictly maintained and neither the state nor the centre can encroach upon the sphere allotted to the other by the Constitution, yet in certain exceptional circumstances the above system of distribution is either suspended or the powers of the Union Parliament are extended over the subjects mentioned in the state list. The exceptional circumstances are: 1. Power of Parliament to legislate in the national interests according to Article 249, if the Rajya Sabha passes a resolution supported by 2nd March of the members present and voting that it is necessary or expedient in the national interest that Parliament should make laws with respect to any matter enumerated within state law, then it shall be lawful for the Parliament to make laws for the whole or any part of the territory of India with respect to that matter so long as the resolution remains in force. Such a resolution normally lasts for a year. It may be renewed as many times necessary but not exceeding a year at a time. 2. During a proclamation of emergency. According to Article 250, while the proclamation of emergency is in operation, the Parliament shall have power to make laws for the whole or any part of the territory of India with respect to all matters in the state list. 3. Parliament's power to legislate with the consent of the states. According to Article 252, if the legislature of two or more states pass resolution to the effect that it is desirable to have a law passed by Parliament on any matters in the state list, it shall be lawful for Parliament to make laws regulating that matter. Any other state may adopt such a law by passing a resolution to that effect. Such law can only be amended or repealed by the Act of Parliament. 4. Parliament's power to legislate for giving effect to treaties and international agreements. Article 253 empowers the Parliament to make any law for the whole or any part of the territory of India for implementing treaties and international agreements and conventions. In other words, the normal distribution of powers will not stand in the way of Parliament to pass a law for giving effect to an international obligation, even though such law relates to any of the subject in the state list. 5. In case of failure of constitutional machinery in a state under Article 256, Parliament is empowered to make laws with respect to all matters in the state list when the Parliament declares that the government of the state cannot be carried on in accordance with the provisions of the Constitution. It is submitted that these provisions enable the centre to legislate in exceptional circumstances on the state subjects without amending the constitutions, and thus introducing a certain amount of flexibility in the scheme of distribution of powers. Thus the framers have incorporated the federal principle in our constitution in a modified form in the light of the experience in other federations and in view of the peculiar requirement of our country. Q. 63. What do you understand by I. Doctrine of repugnancy. 2. Doctrine of pith and substance. 3. Doctrine of colorable legislation. Ans. I. Doctrine of repugnancy. Article 254, 1. Says that if any provision of law made by the legislature of the state is repugnant to any provision of a law made by Parliament, which is competent to enact, or to any provision of the existing law with respect to one of the matters enumerated in the concurrent list, then the law made by Parliament, whether passed before or after the law made by the legislature of such stage, or, as the case may be, the existing law shall prevail, and the law made by the legislature of the state shall, to the extent of the repugnancy, be void. Article 254, 1. Only applies where there is inconsistency between a central law and a state law relating to a subject mentioned in the concurrent list. In M. Karunanidhi v. Union of India, AIR 1979 SS 898, Fazal Ali, J. reviewed all its earlier decisions and summarized the test of repugnancy. According to him, a repugnancy would arise between the two statutes in the following situations. 1. It must be shown that there is clear and direct inconsistency between the two enactments, Central Act and State Act, which is irreconcilable, so that they cannot stand together or operate in the same field. 2. There can be no repeal by implication unless the inconsistency appears on the face of the two statutes. 3. Where the two statutes occupy a particular field, but there is room or possibility of both the statutes operating in the same field without coming into collusion with each other, no repugnancy results. 4. Where there is no inconsistency but a statute occupying the same field seeks to create distinct and separate offences, no question of repugnancy arises, and both the statutes continue to operate in the same field. Clause 2 of Article 254 states that where a law made by a state legislature with respect to a matter in the concurrent list contains any provisions repugnant to the provisions of an earlier parliamentary law or existing law with respect to that matter, then the state law will prevail in the state provided it has been reserved for the President's consideration and has received his assent. This clause is an exception to the general rule embodied to the clause 1 of Article 254 as detailed above. A proviso to clause 2 states that nothing in clause 2 shall prevent Parliament from enacting at any time any law with respect to the same matter, including a law adding to, amending, varying or respecting the law so made by the State Legislature. 2. Doctrine of Pith and Substance. The Privy Council applied this doctrine in Prafulla Kumar Mukherjee v. Bank of Khulna, AIR 1947 PC 60. In this case, the validity of Bengal Money Lenders Act 1946, which limited the amount and rate of interest recoverable by a money lender on any loan, was challenged on the ground that it was ultra vires the Bengal legislature insofar as it related to promissory notes, a central subject. The Privy Council held that Bengal Money Lenders Act was in pith and substance a law in respect of money lending and money lenders a state subject, and was valid even though it trenches incidentally on promissory notes, a central subject. In State of Bombay v. F.N. Balsara, AIR 1951 SC 318, the Bombay Prohibition Act, which prohibited sale and possession of liquors in the state, was challenged on the ground that it incidentally encroached upon import and export of liquor across custom frontier, a central subject. It was contended that the prohibition, purchase, use, possession and sale of liquor will affect its import. The Supreme Court held the Act valid because the pith and substance of the Act fell under the state list and not under Union list, even though the Act incidentally encroached upon the legislative powers of the Union. 3. Doctrine of Colorable Legislation. The doctrine of colorable legislation is based upon the maxim that you cannot do indirectly what you cannot do directly. The doctrine becomes applicable when a legislature seeks to do something in an indirect manner what it cannot do directly. The doctrine thus refers to the question of competence of the legislature concerned to enact a particular law. The Constitution has already distributed legislative powers between the Parliament and state legislatures, and each has power to enact within its legislative spheres, marked out for it by the specific legislative entails. In respect of the subject matter of a particular legislation, the question may arise whether the legislature transgresses the limits imposed on it by the Constitution. Such transgression may be patent, manifest or direct, or may be disguised, covert or indirect. In order to decide to which class of subjects of legislation a statute really belongs, and so whether or not the legislature has transgressed the sphere assigned to it, what material is the substance of the legislation in question, its true nature and character, not its outward or formal appearance. To ascertain the true character and substance of the enactment, courts take into consideration its object, purpose or design. In KCG Narayan Devi, State of Orissa, AIR 1935 SC 375, the Supreme Court explained the meaning and scope of the doctrine of colorable legislation in the following terms. If the Constitution distributes the legislative power amongst different legislative bodies, which have to act within their respective spheres marked out by specific legislative entries, or if there are limitations on the legislative authority in the shape of fundamental rights, question arises as to whether the legislature in a particular case has or has not, in respect to the subject matter of the statute or in the method of enacting it, transgressed the limits of its constitutional powers. Such transgression may be patent, manifest or direct, but it may also be disguised, covert or indirect, and it is to this latter class of cases that the expression colorable legislation has been applied in judicial pronouncements. The idea conveyed by the expression is that although apparently a legislature in passing a statute purported to act within the limits of its powers, yet in substance and in reality it transgressed these powers, the transgression being veiled by what appears, on proper examination, to be a mere pretense or disguise. Q. 64 discuss the methods of administrative control over the state by union. Ans. The relation between the union and the states may be classed under two heads: I. During emergencies, and 2. In normal times. I. During proclamation of any emergency, the union assumes effective control over the state or states as the case may be. The autonomy of the state or states is suspended and the Government of India functions as a unitary government during the emergencies. 2. The supremacy of the union over the states is assumed in normal time also. Article 256 to 263 provide for union control over states even in normal period through the following ways. 1. Direction by the union to the state governments. 2. Delegation of union functions to the states. 3. All India services. 4. Grant and aid. A. Direction by the centre to the state. Article 256 provides that the executive power of the state shall be so exercised as to ensure compliance with the laws made by Parliament, and the executive power of the Union shall also extend to the giving of such directions to a state as it may deem essential for the purpose. Thus power to give direction was necessary because, if the centre was not vested with such power, the proper execution of the laws passed by the Parliament would become impossible. According, Article 257 enacts that the states must exercise their executive power in such a way so as not to impede or prejudice the exercise of the executive power of the Union in the state. For this purpose, the central government can give directions to a state as to in which way the state should exercise its executive power. The powers of the central government also extended to giving directions to a state into specific matters: 1. The construction and maintenance of means of communication which are declared to be of national or military importance. 2. Measures to be taken for the protection of the railway within the states. B. Delegation of union's function to the state. Under Article 258, the Parliament may, with the consent of the state government, entrust either conditionally or unconditionally to that government or its offices functions relating to any matter falling within the executive powers of the Union. Under Clause 2, Parliament is also empowered to use state machinery for the enforcement of Union laws and for this purpose may confer power or impose duties upon the state or its officers or authorities thereof in respect of these matters to see that the laws are made applicable to the state. Like the central government, the state government can also delegate its power to the Union and its officers. Article 258 lays down that the governor of the state may, with the consent of the Government of India, entrust to the government or its officers functions relating to any matter to which the executive power of that government extends. C. All India services. Beside the separate services for the Union and the states, the Constitution provides for the creation of an additional All India service common to the Union and the states. According to Article 312, if the Rajya Sabha passes a resolution supported by not less than two-thirds of the members present and voting that it is necessary or expedient in the nation's interest to do so, Parliament may by law provide for the creation of one or more All India services common to the conditions of persons appointed to any service. The object of this provision is to ensure greater interstate coordination and implementations of the policies of the central government through these officers. This also enables the central government to exercise a control over state in matters of execution of union laws. D. Grants in aid. Under the Constitution, the financial resources of the state are very limited, though they have to do many works of social uplift under directive principles. In order to cope with their ever-expanding needs, the central government makes grants in aid to the states. Grant in aid to states thus serve two purposes. 1. Through its central government exercises a strict control over the state because grants are granted subject to certain conditions. If any state does not agree to the condition, the central government may withdraw the grant, and 2. It generates a center-state coordination and cooperation. If a state wants to develop its welfare schemes for the people of the state, it may ask for financial help from the center. Disputes relating to water. Article 262 authorizes the Parliament to provide by law for adjudication of any dispute or complaint with respect to the uses, distribution, or control of the waters of any interstate rivers and river valleys. Under Clause 2 of this article, Parliament may by law provide that neither the Supreme Court nor any other court shall have any jurisdiction in respect of such disputes and complaints relating to water of interstate rivers and river valleys. Under Article 262, Parliament has passed the River Board Act, 1956, and the Interstate Water Disputes Act, 1956. The Water Dispute Act empowers the central government to set up a tribunal for the adjudication of such disputes. The decision of the tribunal shall be final and binding on the parties to the dispute. Q. 65 describe the financial relation between Union and the states. Or discuss the provisions dealing with distribution of revenue between Union and the state. Ans. Article 268 provides the scheme of the distribution of revenue between the Union and the states. The states possess exclusive jurisdiction over taxes enumerated in the state list. The Union is entitled to the proceeds of the taxes in the Union list. The concurrent list includes no taxes. However, it is to be noted that while the proceeds of taxes within the state lists are entirely retained by the states, proceeds of some of the taxes in the Union list may be allowed, wholly or partially, to the states. The Constitution mentions following categories of the Union taxes which are wholly or partially assigned to the states. 1. Duties levied by the Union but collected and appropriated by the states according to Article 268. Stamps duties and duties of excise on medicinal and toilet preparations mentioned in the Union list shall be levied by the central government. These duties are collected by the states within which such duties are leviable. The proceeds of such duties are assigned to the states. 2. Taxes levied and collected by the Union and assigned to the states. Constitution 80th Amendment Act, 2000. The Constitution, 80th Amendment Act, 2000 has amended Article 269 and substituted new clauses in place of clauses 1 and 2 of Article 269. It has also substituted a new article in place of the existing Article 270 and has deleted Article 272 of the Constitution. The amendment has been enacted on the basis of the recommendations of the 10th Finance Commission. The new clause 1 of Article 269 provides that taxes on sale or purchase of goods and taxes on the assignment of goods shall be levied and collected by the Government of India, but shall be assigned and shall be deemed to have been assigned to states on or after the first day of April 1996 in the manner as may be prescribed by Parliament by law. The expression taxes on the sale or purchases of goods shall mean taxes on sale or purchase of goods other than newspapers, where such sale or purchase takes place in the course of interstate trade or commerce. The new clause 2 of Article 269 provides that the net proceeds in any financial year of any such tax, except in so far as those proceeds represent proceeds attributable to Union territories, shall not form part of the Consolidated Fund of India, but shall be assigned to the states within which tax is leviable in that year, and shall be distributed among those states in accordance with such principles of distribution as may be prescribed by Parliament by law. Taxes levied and collected by the Union but distributed between the Union and states. The Constitution, 80th Amendment, Act 2000 has substituted a new article for Article 270 which shall be deemed to have been substituted with effect from 1st day of April, 1996. The new Article 270 provides that all taxes and duties referred to in the Union list, except the duties and taxes referred to in Articles 271 and any cess levied for specific purposes under any law made by Parliament shall be levied and collected by the Government of India and shall be distributed between the Union and the states in the manner provided in Clause 2. Clause 2 provides that such percentage, as may be prescribed, of the net proceeds of any such tax or duty in the financial year shall form part of the Consolidated Fund of India, but shall be assigned to the states within which that tax or duty is leviable in that year, and shall be distributed among those states in such manner and from such time as may be prescribed in the manner provided in Clause 3. According to Clause 3, the word prescribed in Article 270 means Finance Commission, which will give its recommendation to the government about the actual amount of net proceeds from all taxes and duties leviable by the central government and shall be distributed among the states. This amendment will enhance the income of the states. 4. Taxes for the purpose of the Union. Article 271 provides that Parliament at any time increases any of the duties or taxes mentioned in Articles 269 and 270 by imposing a surcharge. The whole proceeds of any such surcharge shall form part of the Consolidated Fund of India. Q. 66 Write short notes on I. Consolidated Fund of India and of the states. 2. The public accounts of India and of the states. Ans. Consolidated Fund and public accounts of India and of states, subject to the provisions of the Contingency Fund and the provisions with respect to the assignment of the whole or part of the net proceeds of certain taxes and duties of states, all revenues received by the Government of India, all loans raised by that government by the issue of treasure bills, loans or ways and means, advances and all monies received by that government in repayment of loans, shall form one consolidated fund to be entitled the Consolidated Fund of India, and all revenues received by the government of the state, all loans raised by the government by the issue of treasury bills, loans or ways and means, advances and all monies received by that government in repayment of loans form consolidated fund to be entitled the Consolidated Fund of the State. Article 266, 1. All other public monies received by or on behalf of the Government of India or the Government of a state shall be credited to the public accounts of India or the public accounts of the state, as the case may be. Article 266, 2. No monies out of the Consolidated Fund of India or the Consolidated Fund of a state shall be appropriated except in accordance with law and the purpose and in the manner provided in this Constitution. This restriction does not apply to the public accounts. Article 266, 3. Q. 67 describe the provisions relating to the Contingency Fund of India. Ans. Article 267 authorizes Parliament and State Legislature to create a contingency fund formed by such sums as may be determined by law. Article 267, 1, provides that Parliament may, by law, establish a contingency fund of India into which shall be paid from time to time such sums as may be determined by such law, and the said fund shall be placed at the disposal of the President to enable advances to be made by him out of such fund for the purposes of meeting unforeseen expenditure pending authorization of such expenditure by Parliament by law under Article 115 or Article 116. Further, Article 267, 2, lays down that the legislature of a state may by law establish a contingency fund in the nature of an imprest to be entitled to the contingency fund of the state, into which shall be paid from time to time such sums as may be determined by such law, and said fund shall be placed at the disposal of the governor of the state to enable advances to be made by him out of such fund for the purposes of meeting unforeseen expenditure pending authorization of such expenditure by the legislature of the state by the law under Article 205 or Article 206. The contingency fund, whether of the Union or of the state, is an emergency fund for making advances to meet unforeseen expenditures without going through the formality otherwise prescribed for making any expenditure so that the situation may be expeditiously dealt with. Q. 68 discuss the Constitution and functions of the Finance Commission. Ans. According to Article 280, 1, the President shall within 2 years from the commencement of the Constitution, and thereafter at the expiration of every 5th year or at such earlier times as the President considers necessary, by order constitute a Finance Commission which shall consist of a chairman and 4 members to be appointed by the President. Article 280, 2, provides that Parliament may by law determine the qualification which shall be requisite for appointment as member of the Commission and the manner in which they shall be selected. Duties of the Finance Commission. It shall be the duties of the Finance Commission to make recommendations to the President as to A. The distribution between the Union and the states of the net proceeds of taxes which are to be or may be divided between them under this chapter, and the allocation between the states of the respective shares of such proceeds. B. The principle which should govern the grants in aid of the revenues of the states out of the Consolidated Fund of India. C. Any other matter referred to the Commission by the President in the interest of sound finance. The Commission shall determine their procedure and shall have powers in the performance of their functions as Parliament may by law confer on them. Article 281 provides that the President shall cause every recommendations of the Finance Commission to be laid before each House of Parliament together with an explanatory note. The scheme of distribution of revenue indicate like distribution of legislative and administrative powers, a clear tendency towards centralization in favor of the center. The center's resources are vast, but the state resources are very meager, while the responsibilities of states are manifold. The control of center over the finances appears to be a violation of the principles of federation which is adopted in the India Constitution. But it is to be stood in the context of historical background underlying the Indian Constitution, that is for consolidating and strengthening the unity of India. It is the central government which is ultimately responsible for maintaining economic unity and thereby maintaining the welfare of country. Q. 69. Explain the provisions of Constitution relating to right to property. Ans. The Constitution, 44th Amendment, Act, 1978, has omitted Articles 19, 1, F, and 31 from Part 3 of the Constitution, and thus the right to property is no more a fundamental right. The said amendment has added a new chapter by inserting a new Article 300-A which relates to right to property, Chapter 4. Article 300-A is a reproduction of Article 31, 1, according to which no person shall be deprived of his property except by authority of law. Here the law means the ordinary law of land. Hence has authority to take away the property of an individual if it is in accordance with an ordinary law passed by the legislature. Thus, both these questions, that for what purpose property will be taken and whether any compensation will be paid, will be determined by the legislature. Now, right to property not being fundamental right, in case of violation of right to property under Article 300-A, a person will not be entitled to invoke the writ jurisdiction of Supreme Court under Article 32. He will, however, be entitled to invoke the jurisdiction of high courts under Article 226. The eminent jurist Mr. M.C.Y. has strongly criticized by saying that it would destroy the most cherished rights which are embodied in our Constitution. According to him, this amendment has taken away the very valuable rights of an individual. Dr. P.K. Tripathi, in his article Right to Property after 44th Amendment, AIR 1980, Journal 51, concluded that now the right to property of citizens and non-citizens is more comprehensively and firmly secured under the constitutional law of India than ever before. He justified his conclusion by stating that an amendment in existing position will now require not only the procedures laid down in Article 368, but also the consent of the states as required in the proviso to Article 368. In Maneka Gandhi v. Union of India, AIR 1978 SC 597, and later in series of other cases, the Supreme Court has held that the validity of a law passed under the new Article 300-A for the purpose of depriving a citizen of his property can be challenged on the ground of no provision for payment of compensation for the property compulsorily acquired for public purpose. In this case, the meaning and the scope of law has been enlarged. Now, after this decision, term law has been explained as a valid law which is just, fair and reasonable in nature as well as procedure. Any law made under Article 300-A which does not provide for compensation for the property to be acquired compulsorily for public purpose will be declared void, unfair, unjust, unreasonable, hence unconstitutional. Q. 70 discuss the scope and extent of the freedom of trade, commerce and intercourse under the Constitution. Ans. Freedom of trade, commerce and intercourse is secured in India by Article 301, which declares that trade, commerce, and intercourse throughout the territory of India shall be free. Articles 302 to 305 are exceptions to Article 301 of the Constitution. In Eshabri T. Kovi, State of Assam, AIR 1951 SC 232, the validity of the Assam taxation on goods carried by roads or inland waterways Act of 1954 was challenged on the ground that it violated Article 301 of the Constitution and was not saved by Article 304(b). The petitioner carried on the business of growing tea and exporting it to Calcutta via Assam. While passing through Assam, the tea was liable to tax under the said Act. The Supreme Court held that the impugned law undoubtedly levied a tax directly and immediately on the movements of goods, and therefore came within the purview of Article 301. The Act was, therefore, held void. The court said that taxes may and do amount to restrictions if they directly and immediately restrict trade. In Automobile Transport Limited v. State of Rajasthan, AIR 1960 to SC 1906, the appellant challenged the validity of the Rajasthan Motor Vehicles Taxation Act, 1951, inter alia, as violating Article 301. The state government imposed a tax on all motor vehicles used and kept within the state of Rajasthan. The court held the tax valid as they were only regulatory measures imposing compensatory taxes for facilitating trade, commerce, and intercourse. The majority judgment in the Eshabri T. Kovis case read with the majority judgment in the automobiles case lead to the following principles relating of Article 301. 1. Article 301 assures freedom of interstate as well as intrastate trade, commerce, and intercourse. 2. Trade, commerce, and intercourse have the widest connotation and take in movement of goods and persons. 3. The freedom is not only from laws enacted in the exercise of the powers conferred by the legislative entries relating to trade and commerce or production, supply and distribution of goods, but also to all laws including tax laws. 4. Only those laws whose direct and immediate effect to inhibit or restrict freedom of trade or commerce will come with the mischief of Article 301. 5. Laws which are merely regulatory or which impose purely compensatory taxes, and hence intended to facilitate freedom of trade, are outside the scope Article 301. Exceptions to right. Freedom of trade, commerce and intercourse, as contained in Article 301 is subject to restrictions imposed in Article 302 to 305 of Constitution. These restrictions are as follows. 1. Parliament's power to regulate trade and commerce in the public interest. Article 302 authorize President to impose such restrictions on the freedom of trade, commerce and intercourse between one state and the other or within any part of the territory of India, as may be required in the public interest. The question whether a restriction imposed by Parliament by law in the public interest or not is justiciable issue. In that case, Parliament is given the sole power to decide what restrictions can be imposed in the public interest as authorized by Article 302. It has been held in Surajmal Roop Chand and Kovi, State of Rajasthan, AIR 1967 Raj. 104. That restrictions imposed on the movement of grain under the Defence of India Rules, 1962 are in the public interest. 2. Parliament's power to discriminate between states on the ground of exigencies of situations. Article 303. 1. Provides that Parliament will not give any preference to one state over another or discriminate between the states by virtue of an entry relating to trade and commerce in any of the lists, but Article 303. 2. Gives power to the Parliament to give preference over other states, if it is declared by law made by Parliament that it was necessary to do so for the purpose of dealing with a situation arising from any scarcity of goods in any part of India. 3. States' power to regulate trade and commerce. Article 304. 1. Provides that state may by law impose on goods imported from other state any tax to which similar goods manufactured or produced in that state are subject so, however, as not to discriminate between goods so imported and goods so manufactured or produced. Thus what Article 304a ensures is that so far as taxation is concerned, interstate commerce must be put at par with the intrastate commerce. But Article 304b authorizes a state to impose by law such reasonable restrictions on the freedom of trade, commerce and intercourse with or within that state as may be required in the public interest, provided the bill or amendment for this purpose has received the previous sanction of the President before it is introduced or moved in State Legislature. Hence, a law passed by a state to regulate interstate trade and commerce must satisfy the following conditions under Article 304b. 1. Previous sanction of the President of India must be obtained. 2. The law must be in public interest. 3. Restrictions imposed by such a law must be reasonable. In this way, it is obvious that Parliament has powers to regulate trade, commerce and intercourse in the country. 4. Saving of existing laws. Article 305 saves the existing laws from the operation of Articles 301 and 303 except in so far as the President may by order otherwise directs. Existing law is defined in Article 366. 10. As any law, ordinance, order, bylaw, rule or regulation passed or made before the commencement of the Constitution by any legislature or authority. In Sagir Ahmed v. State of UP, AIR 1964 SC 728, the Supreme Court raised the question whether an act providing for state monopoly in a particular trade or business conflicts with the freedom of trade and commerce guaranteed by Article 301 but left the question undecided. Article 19 was amended by the Constitution, IST Amendment Act, 1951, in order to take out such state monopolies out of the purview of Article 19, 1g. It was held in the above case that as a matter of precaution, the laws creating state monopolies would not be declared invalid as infringing Article 301, for which the amendment was added in Article 305. Thus, a state or the centre now can run any business on a monopolistic basis, and it would not be bad under Article 305 of the Constitution, because such monopolies are reasonable restrictions in public interest. Q. 71 explain the doctrine of pleasure and state the exceptions enumerated in the Constitution of India. Ans. Doctrine of pleasures in England. The normal rule is that a civil servant of the Crown holds his office during the pleasure of the Crown. This means that his services can be terminated at any time by the Crown without assigning any reason. Even if there is a contract of employment between the Crown is not bound by it. In other words, if a civil servant is dismissed from service, he cannot claim arrears of salary or damages for premature termination of his service. The doctrine of pleasure is based on the public policy. Article 310 of the Indian Constitution incorporates the common law doctrine of pleasure. It expressly provides that all persons who are members of the defense services or the civil services of the Union of All India Services hold office during the pleasure of the President. Similarly, members of the state services hold office during the pleasure of the Governor. But this rule of English law has not been fully adopted in this article. Thus, Article 310 itself places restrictions and limitations on the exercise of the pleasure under Article 310 is limited by Article 311(2). The services of permanent government servant cannot be terminated except in accordance with rules made under Article 309, subject to the procedure in Article 311(2) of the Constitution and the fundamental rights. The above doctrine of pleasure is invoked by the government in the public interest after a government servant attains the age of 50 years or has completed 25 years of service. This is constitutionally permissible as compulsory termination of service under FR 56(b) does not amount to removal or dismissal by way of punishment. While the government reserves its right under FR 56(b) to compulsory retire a government servant even against his wish, there is a corresponding right of the government servant under FR 56(c) to voluntarily retire from service by giving the government 3 months' notice. Restriction on doctrine of pleasure. The Constitution lays down the following limitations on the exercise of the doctrine of pleasure. 1. The pleasure of the President or Governor is controlled by provisions of Article 311, so the field covered by Article 311 is excluded from the operation of the doctrine of pleasure. Motiram v. North Eastern Frontier Railway, AIR 1964 SC 600. The pleasure must be exercised in accordance with the procedural safeguards provided by Article 311. 2. The tenure of the Supreme Court judges, Article 124, High Court judges, Article 218, Auditor General of India, Article 148(2). The Chief Election Commissioner, Article 324, and the Chairman and members of the Public Service Commission, Article 317, are not dependent on the pleasure of the President or the Governor, as the case may be. These posts are expressly excluded from the operation of the doctrine of pleasure. 3. The doctrine of pleasure is subject to the Fundamental Rights, Union of India v. PD. More. AIR 1962 SC 630, General Manager, S. RLY. V. Rangachari, AIR 1962 SC 36. Q. 70 to discuss the scope of constitutional protection of civil servants in India. Ans. Constitutional safeguards to civil servants. Article 311, 1, provides no person who is a member of a civil service of the Union or an All India service or a civil service of a state or holds a civil post under the Union or a state shall be dismissed or removed by an authority subordinate to that by which he was appointed. Clause 2 of Article 311 lays down no such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of the charges. These above-mentioned provisions enact the general principle that a government servant holds office during the pleasure of the government, with following restrictions on the prerogative of dismissal at pleasure. To sum up, the contents of Article 311 are: I. The persons employed in civil capacities under the union or state shall not be dismissed or removed by an authority subordinate to that by which they were appointed, and 2. No such person shall be dismissed or removed or reduced in rank except after an inquiry as provided in Clause 2 of Article 311. These restrictions are constitutional safeguards of the civil servants. No removal by a subordinate authority. Supreme Court has held in Maheshwi, State of UP, AIR 1955 SC 70, that it does not mean that the removal or dismissal must be by the same authority who made the appointment or his direct superior. In this case, the person appointed by the Divisional Personnel Officer, EIR, was dismissed by the Superintendent, Power, EIR. The court held the dismissal valid as both the officers were of the same rank. Reasonable opportunity to defend. The rule of reasonable opportunity embodied in Article 311(2) is the most important safeguard furnished to a civil servant under the India Constitution. Two important questions regarding Article 311(2) are: I. Who can invoke the protection of this article and when? 2. What is the content of the words reasonable opportunity used in Article 311(2)? I. When and to whom Article 311(2) applies. Article 311(2) applies only the persons who are members of a civil service of the Union or of an All India service or of a civil service of a state, or to persons who hold a civil post under the Union or a state. These safeguards are not applicable to members of defense forces or to any posts connected with defense. Thus, the protection under Article 311 is not available to military personnel who are governed by the Army Act. Their services can be terminated without assigning any reasons. The Supreme Court has held in Sukhdev Singh v. Bhagat AIR 1975 SC 1331 that statutory corporations such as LIC, ONGC and Industrial Finance Corporation are state under Article 12, but protection of Article 311(2) is not available to their employees. The provisions of Article 311 are applicable both to permanent and temporary servants, as has been held by the Supreme Court in Parshottam Lal Dhingra v. Union of India, AIR 1958 SC 56. However, suspension of a government servant from service is neither dismissal nor removal and is, therefore, not within the scope of protection of Article 311 of the Constitution. Reasonable opportunity to defend. Article 311(2) lays down that a civil servant cannot be dismissed or removed or reduced in rank unless he has been given reasonable opportunity to show cause against the action proposed to be taken against him. Originally, the opportunity to defend was given to a civil servant at two stages, I. At the inquiry stage, and this is in accord with the rule of principles of natural justice that no person should be condemned without hearing, 2. At the punishment stage, when after enquiry charges have been proved and any of the three punishments, dismissal or removal or reduction in rank, were proposed to be taken against him. The Constitution, 42nd Amendment Act, 1976, has abolished the right of the government servant to make representation at the second stage of the enquiry. The newly added proviso to Article 311(2) makes it clear that if after enquiry it is proposed to enforce upon a person any of the above-mentioned punishments, they may be imposed on the basis of the evidence given during such enquiry, and he shall not be entitled to make any representation. The protection under Article 311 2 is available only when dismissal, removal or reduction in rank has been inflicted on a civil servant by way of punishment and not otherwise. The protection of Article 311(2) will not be available to a civil servant in following situations. 1. Where a civil servant has been dismissed or removed or reduced in rank on the ground of misconduct which has led to his conviction on criminal charges. 2. Where it is impracticable to provide a civil servant an opportunity to defend himself, but the authority taking action against him shall record the reasons for such action. 3. According to proviso of Article 311, where the interest of the security of state is pertinent, it will not be expedient to provide an opportunity to defend the concerned civil servant. Q. 73 discuss the composition and function of Public Service Commission in Union and State. Ans. Public Service Commission. The Constitution provides for the establishment of Public Service Commission for the Union and for each state. Article 315, 1. 2 or more states may agree to have common Public Service Commission. Article 315, 2. The Union Public Service Commission, if requested by the Governor of State, may with the approval of the President, agree to act for a state. Appointment of members of Public Service Commission. The chairman and members of the Union Public Service Commission or a joint commission are appointed by the President and in the case of a state commission by the Governor. Article 316, 1. But as nearly as may be 1/2 of the members of every Public Service Commission must be persons who at the dates of their appointments have held office for at least 10 years under the Government of India or the Government of a state. A member of Public Service Commission shall hold office for a period of 6 years. Unless he attains the age of 65 in case of Union Commission or 60 years in case of State Commission, whichever is earlier. If he attains the age of retirement, he has to retire even before the expiry of normal terms of 6 years. A member may himself resign from his office. He may also be removed from his office by order of the President on the ground of misbehavior, if on reference made by the President the Supreme Court, after inquiry, report to the President that he should be removed. If the chairman or any other member of a Public Service Commission is or becomes in any way concerned or interested in any contract, agreement made by or on behalf of the Government of India or state government or participates in any way in the profits or emolument resulting from such contract or agreement, he shall be deemed to be guilty of misbehavior. Article 317, 1. Functions of Public Service Commission. It shall be the duty of the Union and the State Public Service Commission to conduct examinations for appointments. If requested by 2 or more states, it shall be obligatory on the Union Public Service Commission to assist them in devising of joint recruitment for services requiring special qualifications. The Union or State Commissions must be consulted. 1. In all matters relating to methods of recruitment to civil posts. 2. On the principles to be followed in making appointments, promotions and transfers and the suitability of candidates. 3. On disciplinary matters affecting a person in service under the central or state government. 4. On any claim by such a person for the costs incurred in defending legal proceedings instituted against him in respect of acts done or purporting to be done in the execution of his duty. 5. On any claim for compensation in respect of injuries sustained by a person while in service of the government. In all above matters it shall be the duty of the Commission to advise. However, the President and the Governors make regulations specifying the matters in which, either generally or in any particular circumstances, the Commission may not be consulted. Article 2033. The functions of Public Service Commission are only advisory, and the Constitution has no provision to make it obligatory upon the government to act upon the advice of the Commission in any case. Additional functions may be assigned to the Union and State Public Service Commission by an Act of Parliament and State Legislature. Article 321. The expenses of the Union or a State Public Service Commission and the salaries, allowances of its members are charged on the Consolidated Fund of India or state, as the case may be. Article 322. The commissions shall submit an annual report on the work done by them to the President or Governor, as the case may be. The reports are to be laid before the Parliament and the state legislatures, respectively, together with a memorandum as regards the cases where the advice of the Commission was not accepted and the reasons for such non-acceptance. Article 323, 1 and 2. Q. 74 discuss how the administrative tribunals and tribunals for other matters shall be constituted. Discuss the scope and extent of their powers and functions. Ans. The Constitution, 42nd Amendment, Act, 1976 has added a new Part 14A to the Constitution. This Part 14A consists of two Articles 323-A and 323-B which empower the Parliament to establish hierarchy of tribunals to decide disputes relating to tax matters, export, imports, labor disputes, matters relating to land reform and urban sealings, election disputes, service matters, and matters relating to supply of essential commodities. Administrative Tribunals for Service Matters. Article 323- provides for the establishment of administrative tribunals for the adjudication of disputes of government servants. Article 323- lays down 1. Parliament may, by law, provide for the adjudication or trial by administrative tribunals of disputes and complaints with respect to recruitment and conditions of service of persons appointed to public services and post in connection with the affairs of the Union or of any state or of any local or other authority within the territory of India or under the control of the Government of India or any corporation owned or controlled by the government. 2. A law made under Clause 1 may make provisions for a separate administrative tribunal for the Union and each state or for two or more states. B. Of the jurisdiction, powers, including the power to punish for contempt, and authority which may be exercised by each of said tribunals. C. Of the procedure, including provisions as to limitation and rules of evidence to be followed by the said tribunals. D. Excluding the jurisdiction of all courts, except the jurisdiction of the Supreme Court under Article 136, with respect to the disputes or complaints referred to in Clause 1. E. The transfer of all cases to tribunals which were pending in any court or authority before the establishment of such tribunals. F. Repeal or amend any order made by the President. Consequential provision, including provisions as to fees, as Parliament may deem necessary for the effective functioning of and for the speedy disposal of cases by and the enforcement of the orders of such tribunals. 3. The provisions of this article shall have effect notwithstanding anything in any other provision of this Constitution or any other law for the time being in force. Tribunals for other matters. Article 323-B. Article 323-B empowers Parliament and a state legislature to establish tribunals for the adjudications of any disputes, complaints or offences with respect to all or any of the matters specified in Clause 2 of this article. The matters referred to in Clause 2 are the following, namely: A. Levy, assessment, collection and enforcement of any tax. B. Foreign exchange and export. C. Industrial and labor disputes. D. Land reforms laws enacted under Article 31- of the Constitution. E. Sealing on urban property. F. Election disputes of members of Parliament or the state legislatures, but excluding the matters referred to in Articles 329 and 329-A. These articles have taken away the jurisdiction of the courts to decide election disputes of the Prime Minister and Speaker of the Lok Sabha. G. Production, procurement, supply and distribution of foodstuffs and essential goods and control of prices of such goods. H. Rent, its regulation and control and tenancy issues including the rights, title and interests of landlords and tenants. I. Offences against laws with respect to any of the matters specified in subclauses A to H and fees in respect of any of those matters. J. Matters incidental to any of the matters specified in the above subclauses. Such a law will define the jurisdiction and powers of such tribunals and will lay down procedure to be followed by the said tribunals. Appeal to Supreme Court by special leave under Article 136. Though the writ jurisdiction of high courts has now been taken away, but an aggrieved party can still go to Supreme Court under Article 136 of the Constitution. The Supreme Court has already laid down the guidelines for the grant of special leave to appeal from the decision of the tribunals. Under the powers of Article 323-A, the central government has established one central administrative tribunal at Delhi and 8 additional branches at different states which started functioning with effect from 1st November 1985. Q. 75 discuss the composition and functions of Elections Commission. Ans. Election Commission. To ensure free, fair and impartial election, the Constitution establishes the Election Commission, a body autonomous in character and free from political or executive influence. The Commission is an all-India body having jurisdiction over elections to Parliament, State Legislature, offices of the President and Vice President. Article 324 provides for appointment of an election commission to superintend, direct and control elections. Its composition: the election commission consists of the chief election commissioner and such number of election commissioners, if any, as the President may fix from time to time. According to Article 324, 2. All these commissioners are appointed by the President subject to the provisions of any law enacted by Parliament for the purpose. Article 324, 4. Provides that the President may appoint, after consultation with the Election Commission, such regional commissioners as the President may consider necessary to assist the Election Commission in the discharge of its functions. The regional commissioners may be appointed before each general election of Lok Sabha and state legislative assemblies and also the biennial election to the state legislative councils. Article 324(3) provides that Chief Election Commissioner acts as the chairman of the Election Commission. The President may determine by making rules the conditions of service and tenure of office of the election commissioners and regional commissioners. This is, however, subject to the law made by the Parliament. Article 324 provides that the tenure of Chief Election Commissioner is independent of the executive discretion, for he cannot be removed from his office except in the like manner and on the same grounds as a judge of the Supreme Court. Further, the conditions of his service cannot be varied to his disadvantage after appointment. He can therefore discharge his functions without fear or favor. In S.S. Dhannovi, Union of India, AIR 1991 SC 1745, Supreme Court has held that election commissioners cannot be placed at par with the Chief Election Commissioner in terms of power and authority. On 2nd October 1993, the government issued an ordinance, which is now on Act, and converted the one-man election commission into a multi-member commission by appointing 2 persons as election commissioners. The ordinance provides specifically that the decision of 3 members election commission shall, as far as possible, be unanimous. But, in case of difference of opinion between the Chief Election Commissioner and other election commissioners, the matter shall be decided according to the opinion of the majority. The ordinance has amended the law and equated the 2 election commissioners with the CEC in respect of salary and other terms of service. In a significant judgment in T.N. Sheshan v. Union of India, 1995, 4 SCC 611, a 5-judge Constitution bench of the Supreme Court unanimously upheld the validity of the Act equating the status, power and authority of 2 election commissioners with that of CEC. The Chief Election Commissioner Mr. T.N. Sheshan had challenged the validity of the ordinance and the Act on the ground that it was arbitrary, unconstitutional and void. Delivering the judgment of the court, Ahmadi, C.J. held that the CEC does not enjoy a status superior to other ECs. Although there are 2 differences between the service conditions of CEC and other ECs, such as the CEC can only be removed from his office in the like manner and on the like ground as a judge of the Supreme Court, and that conditions of service cannot be varied to the disadvantage of the CEC after his appointment, while other ECs can be removed on the recommendation of the CEC, but that is not an indicia for conferring a higher status on CEC. Article 324 envisages a permanent body to be headed by a permanent incumbent, namely, the CEC. The scheme of Article 324 clearly provides for a multi-member body comprising the CEC and the election commissioners, ECs. Functions of Election Commission according to Article 324. 1. The Election Commission performs the following functions: the superintendence, direction and control of the preparation of the electoral rolls and also the conduct of elections to Parliament, State Legislatures and to the offices of President and Vice President. There shall be 1 general electoral roll for every territorial constituency. Article 325. No person shall be ineligible for inclusion in any such roll on grounds only of religion, race, caste, sex or any of them. The elections to the Parliament and State Legislatures are to be held on the basis of adult suffrage. Every person who is a citizen of India and who is not less than 18 years of age is not otherwise disqualified under this Constitution or any law, Representation of People's Act, 1950, made by the legislature on the ground of non-residence, unsoundness of mind, crime, or illegal practice, has a right to be registered as a voter. Article 326. Power of Parliament and State Legislatures with regard to election law. Article 327 empowers Parliament to make provisions with respect to all matters relating to or in connection with election to Parliament and State Legislature, the preparation of electoral rolls, the delimitation of constituencies, and all other connected matters. In exercise of the power conferred by Article 327, Parliament has enacted the Representation of People's Acts, 1950 and 1951, the Presidential and Vice Presidential Elections Act, 1952, and the Delimitation Commission Act, 1952. Article 328 confers a similar power on state legislatures. The state legislature can make laws relating to all the above matters referred to under Article 327, insofar as provision in that behalf is not made by Parliament. In Special Reference Number 1 of 2002, AIR 2003 SC 87, the President has referred the important question regarding interpretation of Article 174 and Article 324 to the Supreme Court for its opinion under Article 143 of the Constitution. Under Article 174, the government has power to dissolve the State Legislative Assembly from time to time and place as he thinks fit. This power, however, is exercised by the government. But it also provides that 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. This means that in normal situation, if a legislative assembly is dissolved, election must be held and the assembly be constituted to meet within that period. Article 324 vests power of superintendence, direction and control of the preparation of the electoral rolls for and the conduct of all elections to Parliament and the legislature of every state under this Constitution. Under Article 356 there is a provision for the presidential's rule in a state. The facts were that there was an unfortunate accident in Godhra in Gujarat on 27 February 2002 in which 58 Kar Sevaks were burnt alive in a train in which they were returning from Ayodhya to their homes. As a result of this, there was widespread communal riots in certain areas of state. The Chief Minister then took a political move and prematurely dissolved the Assembly on 27 July 2002 and recommended for election. The Election Commissioner visited the state to take the stock of situation and took the decision that condition in the state was not conducive for holding the assembly election. It even recommended for the imposition of President's rule after the lapse of 6 months. In view of this, the government referred 3 questions to the Supreme Court for its opinion. 1. Whether Article 174 is subject to the decisions of the Election Commission not to hold elections in a state under Article 324. 2. Whether the Election Commission can declare election schedule which violates Article 174 and after the expiry of 6 months constitutional period for Assembly to meet necessitating the imposition of President's rule under Article 356. 3. Whether the mandate of Article 174 to hold election will be fulfilled by the holding of election by commission under Article 324. A 5-judge bench headed by the Chief Justice B.N. Kirpal rejected the contention of the Gujarat government that Article 174 of the Constitution, which mandates that not more than 6 months shall lapse between 2 sittings of an elected assembly, and held that Article 174, 1, does not apply to a dissolved assembly whose life has come to an end and ceased to exist but applies to a live assembly. The court said that Art. 174(1) neither relates to elections nor does it provide any outer limit for holding elections for constituting the Legislative Assembly. The court held that the holding of elections is the exclusive domain of the Election Commission under Article 324 of the Constitution. The court said that this was evident from Sections 14 and 15 of the Representation of People Act, which provide that the President or the Governor shall fix the date for holding elections on the recommendations of the Election Commission. Regarding whether Article 174 would yield to Article 324, the court said that Article 174(1) and Article 324 operate on different fields, and neither Article 174(1) is subject to Article 324 nor Article 324 is subject to Article 174(1). Q. 76 discuss how the Constitution protects the rights of minorities in India. Ans. The Constitution of India does not recognize religious minorities. All votes shall be enrolled in one general electoral roll for any territorial constituency. Article 325. There is no discrimination on the grounds of religion, caste, race, or tribe in election or public services. The Constitution, however, recognizes linguistic and cultural minorities. Any section of the citizens of India having a distinct language, script or culture shall have the right to conserve the same. Article 29(1). They may have their educational institutions of their own choice. Article 30. They may get the language spoken by them officially recognized. Article 347. There is no reservation of seats in the House of People or Legislative Assembly for any community, except scheduled castes and scheduled tribes and Anglo-Indians. Articles 330 to 333. The claims of scheduled castes and tribes shall be taken into consideration in making appointments to public services consistently with efficiency of the administration. Article 335. During the first 2 years after the commencement of this Constitution, appointment of Anglo-Indians to posts in the railways, customs, postal and telegraph services shall be made on the same basis as immediately before the 15th August 1947. There shall be successive reduction in such reservation by 10% after every 2 years. Article 336. The President or Governor, as the case may be, may nominate to members of the Anglo-Indian community to Parliament or the Legislative Assembly if their representation is inadequate. Such representation in Parliament or legislative assemblies or public services for any community shall cease on the expiry of 10 years after the commencement of the Constitution. Articles 344, 356. Reservation of seats and special representation to cease after 20 years. Article 334 of the Constitution of India as amended by the Constitution, 23rd Amendment, Act, 1969, provides that a. The reservation of seats for the scheduled castes and the scheduled tribes in the House of the People and b. The representation of the Anglo-Indian community in the House of the People and the Legislative Assembly of the States by nomination shall cease to have effect on the expiration of a period of 40 years, amended by 45th Amendment Act 1980, from the commencement of this Constitution. Formerly, the period of reservation was intended to be only 14 years from the commencement of the Constitution, but now by the new amendment, i.e., the Constitution, 23rd Amendment, Act, 1969, the reservation will continue for 30 years, 45th Amendment, Act has amended the Article 336 and now expiry period has been extended up to 40 years instead of 30 years. Q. 77. What are the special provisions contained in the Constitution for the protection of interest of the scheduled castes and scheduled tribes? Discuss. Ans. The Constitution has not defined as to which are the sections of scheduled castes and scheduled tribes. It, however, empowers the President to draw up list of these castes and specify as the scheduled castes and scheduled tribes by a notification. The governor of a state has the similar power for the state. Any alteration in the list is within the power of the Parliament. However, following are the special provisions for the protection of the interest of the scheduled castes and scheduled tribes. 1. According to Article 330, seats shall be reserved in the House of the Peoples for A. The scheduled castes. B. The scheduled tribes. C. The scheduled tribes in the autonomous districts of Assam. 2. Article 332 provides that seats shall be reserved for the scheduled castes and scheduled tribes in the Legislative Assembly of every state. 3. According to Article 334, the reservation of seats for the scheduled castes and scheduled tribes shall cease to have effect after the expiry of period of 50 years from the commencement of the Constitution. 4. Reservation of posts for the appointment of candidates in the services of the Union and States shall be made under Article 164(4) of the Constitution in favor of scheduled castes and scheduled tribes candidates. 5. Article 15(4) provides that nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of any socially and educationally backward classes or citizens or for scheduled castes and scheduled tribes. 6. Article 338(1) provides that there shall be a special officer for the scheduled castes and scheduled tribes to be appointed by the President. Clause 2 of Article 338 provides that it shall be the duty of the special officer to investigate all matters relating to the safeguards provided for the scheduled castes and scheduled tribes and to report to the President upon the working of such safeguards at such intervals as the President may direct, and the President shall cause all such reports to be laid before the Parliament. 7. According to Article 339(1), the President may at any time and shall at the expiration of 10 years from the commencement of the Constitution, by order appoint a commission to report on the administration of the scheduled areas and the welfare of the scheduled tribes in the state. The Union government shall have power to give directions to the state governments to draw up and execute the schemes specified in the direction to be essential for the welfare of the scheduled tribes in the state. The above are in nutshell the constitutional provisions for the protection of interests of the scheduled castes and scheduled tribes. Q. 78 discuss the constitutional provisions relating to the official language of the Union and the states. Ans. According to Article 343(1) of the Constitution, the official language of the Union shall be Hindi in Devanagari script. However, the form of numericals to be used for the official purposes of the Union shall be International Form of Indian numericals. Article 343(2) provides that for a period of 15 years from the commencement of the Constitution, the English language shall continue to be used for all the official purposes of the Union. Even during this period of 15 years, The President may authorize the use of the Hindi language in addition to the English language and of the Devanagari form of numericals for any of the official purposes of the Union. Article 343 lays down that Parliament may, by law, provide for the use, after the set period of 15 years, of a. the English language, b. the Devanagari form of numerals, for such purposes as may be specified in law. Article 343. Official language of states. The legislature of a state may, by law, adopt any one or more of the languages in use in the state or Hindi as the language or languages to be used for all or any of the official purpose of the state. Until the legislature of the state otherwise provides by law, the English language shall continue to be used for those official purposes within the state for which it was being used immediately before the commencement of this Constitution. Art. 345. Q. 79. What is the language for communications between the Union and a state and the states inter se? Discuss the Constitution and function of the Commission and Committee of Parliament on Official Language. Ans. The language for the time being authorized for use in the Union for official purpose shall be the official language for communication between one state and another state and between a state and the Union. Provided that if two or more states agree that the Hindi language shall be the official language for communication between such states, the language may be used for such communication. Article 346. Commission and Committee of Parliament on Official Language. The Constitution provides for the appointment of a commission as well as a committee of Parliament to advise the President on certain matters relating to the official language. According to Article 334, 1. The President shall, at the expiration of 5 years from the commencement of this Constitution, and thereafter at the expiration of 10 years from such commencement, by order constitute a commission which shall consist of a chairman and such other members representing the different language specified in the 8th schedule as the President may appoint, and the order shall define the procedure to be followed by the commission. Article 344, 1. It shall be the duty of the Commission to make recommendations to the President as to a. the progressive use of the Hindi language for the official purposes of the Union, b. restrictions on the use of the English language for all or any of the official purposes of the Union, c. the language to be used for all or any of the purposes mentioned in Article 348, d. the form of numerals to be used for any one or more specified purposes of the Union. E. Any other matter referred to the Commission by the President as regarded the official language of the Union and the language for communication between the Union and a state or between one state and another, and their use. Article 344, 2. In making their recommendations under Clause 2, the Commission shall have due regard to the industrial, cultural and scientific advancement of India, and the just claims and the interest of persons belonging to the non-Hindi speaking areas in regard to the public services. Article 344, 3. There shall be constituted a committee consisting of 30 members, of whom 20 shall be members of the House of the People and 10 shall be members of the Council of State to be elected respectively by the members of the House of the People and the members of Council of States in accordance with the system of proportional representation by means of the single transferable vote. Article 344, 4. It shall be the duty of the committee to examine the recommendation of the commission constituted under clause 1 and to report to the President their opinion thereon. Article 344, 5. Notwithstanding anything in Article 348, the President may, after consideration of report referred to in clause 3, issue direction in accordance with the whole or any part of that report. Article 344, 6. In Union of India v. Murasoli, AIR 1977 SC to 25, the respondents filed writ petitions in the High Court for declarations that the President order which requires training of administrative personnel in Hindi while in service is void. It was contended that presidential order ceased to have any effect because the Second Language Commission was not appointed as required u Article 344. The Supreme Court held that presidential order was valid. The power to appoint commission under Article 344 cannot be said to be exhausted on the expiry of 15 years. The President can use it on more than one occasion. The order continues itself at the end of 15 years. Q80 discuss the provisions of different types of emergency under the Constitution of India. Ans. The Constitution of India provides for 3 types of emergency. A. National emergency due to war, external aggression or armed rebellion, Article 352. B. State emergency due to the failure of constitutional machinery in states, Article 356. C. Financial emergency, Article 360. A. National emergency, Article 352 provides that if the President is satisfied that a grave emergency exists whereby the security of India or any part of India is threatened, either by war or external aggression or armed rebellion, he may make a proclamation of emergency in respect of the whole of India or any part of India as may be specified in the proclamation. The proclamation of emergency made under clause 1 may be varied or revoked by the President by a subsequent proclamation, CI. 2. The President shall not issue a proclamation under clause 1 or a proclamation varying such proclamation unless the decision of the Union Cabinet, i.e. the Council consisting of the Prime Minister and other ministers of Cabinet rank appointed under Article 75, that such a proclamation may be issued has been communicated to him in writing. The proclamation of emergency must be laid before each House of Parliament, and it shall cease to be in operation at the expiration of 1 month prior to the 44th Amendment to months, unless before the expiry of 1 month it has been approved by resolutions of both Houses of Parliament. If the proclamation of emergency is issued at a time when the Lok Sabha has been dissolved, or the dissolution of the Lok Sabha takes place during the period of 1 month referred to above, without approving the proclamation, but the proclamation has been approved by the Rajya Sabha, the proclamation shall cease to operate at the expiration of 30 days from the date on which the Lok Sabha sits after fresh election, unless before the expiry of the above period of 30 days a resolution approving the proclamation has been passed by the Lok Sabha, CI.4. A resolution approving the proclamation must be passed by special majority, that is by a majority of the total members of each House and also by a majority of not less than 2/3 of the members present and voting in each House. Prior to the 44th Amendment, such resolution could be passed by Parliament by a simple majority. A proclamation of emergency once approved by Parliament shall remain in force for a period of 6 months from the date of the passing of the second resolution approving in under clause 4 unless revoked earlier. For the further continuance of the emergency beyond the period of 6 months, approval by Parliament would be required every 6 months. If the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuance of emergency, but it has been approved by the Rajya Sabha, the proclamation shall cease to operate at the expiry of 30 days after the Lok Sabha sits after fresh election unless before the expiry of the above period it is approved by the Lok Sabha, CL.5. Here also the resolution is required to be passed by the special majority referred to above. The President shall revoke a proclamation of emergency or a proclamation varying such proclamation if the Lok Sabha passes a resolution disapproving it or disapproving its continuance. Where a notice in writing signed by not less than 1/10th of the total number of members of the Lok Sabha have been given their intention to move a resolution for disapproving the continuance of a proclamation of emergency, A. to the Speaker, if the House is in session, or B. to the President, if the House is not in session. A special sitting of the Lok Sabha shall be held within 14 days from the date on which such a notice is received by the Speaker or the President for the purpose of considering the resolution, CLs 7 and 8. In Minerva Mills Limited v. Union of India, AIR 1980 SC 1789, Bhagwati, J. has held that there is no bar to judicial review of the validity of a proclamation of emergency issued by the President under Article 352(1). Merely because a question has a political complexion, it is no ground why the court should shrink from performing its duty under the Constitution if it raises an issue of constitutional determination. Effects of proclamation of emergency. The following are the consequences of the proclamation of emergency. 1. Extension of centre's executive power. Article 353. During the operation of a proclamation of emergency, the executive power of the Union extends to giving of directions to any state as to the manner in which the executive power of the state is to be exercised. The 42nd Amendment made a consequential change in Article 353 following the amendment made in Article 352. It provides that the executive power of the Union to give directions under Clause A and the power to make laws under Clause B shall also extend to any state other than the state where emergency is in force, if the security of India or any part of the territory is threatened by activities in or in relation to that part of the territory of India in which the proclamation of emergency is in operation. 2. Parliament empowered to legislate on state subjects. Article 353. B. While the proclamation of emergency is in operation, the Union Parliament is empowered to make laws with respect to any of the matters in the state list. 3. Centre empowered to alter distribution of revenue between the Union and the state. Article 354. The President may, while a proclamation of emergency is in operation by the order after the financial arrangement between the state and the Union as provided in Articles 268 to 279. Every such order is to be laid before each House of Parliament and will come to an end by the end of the financial year in which the proclamation of emergency ceases to operate. Four. Extension of life of Lok Sabha. Article 83. 2. While the proclamation of emergency is in operation, the President may extend the normal life of the Lok Sabha by a year each time up to a period not exceeding beyond 6 months after proclamation ceases to operate. 5. Suspension of fundamental rights guaranteed by Article 19. Article 358 provides for suspension of the 6 freedoms guaranteed to the citizens by Article 19 of the Constitution. It says that while a proclamation of emergency is in operation, nothing in Article 19 shall restrict the power of the state to make any law or to take any executive action abridging or taking away the rights guaranteed by Article 19 of the Constitution. It means that as soon as the proclamation of emergency is made, the freedoms guaranteed by Article 19 are automatically suspended. The 44th Amendment, Act 1978 has made two important changes in Article 358. Article 19 will be suspended only when a proclamation of emergency is declared on the ground of war, external aggression, and not when the emergency is declared on the ground of armed rebellion. And 2. Article 358 will only protect emergency laws from being challenged in the court of law and not other laws which are unrelated to the emergency. The Supreme Court in Pathak v. Union of India, AIR 1973 SC 106 held that the effect of proclamation of emergency on fundamental rights is that the rights guaranteed by Articles 14 and 19 are not suspended during emergency, but their operation is only suspended. This means that only the validity of an attack based on Articles 14 and 19 is suspended during the emergency. Article 359 empowers the President to suspend the right to enforce fundamental rights guaranteed by Part 3 of the Constitution. He may by order declare that the right to move any court for the enforcement of such of the fundamental rights as may be mentioned in the order. Constitution, 44th Amendment, Act exclude Articles 20 and 21 from such order, and all proceedings pending in any court for the enforcement of such rights shall remain suspended for the period the proclamation is in force or for such shorter period as may be specified in the order. An order made under may extend to the whole or any part of the territory of India. CL 2. An order made under CL 1 shall, as soon as possible, be laid before each House of Parliament. CL.3. Thus the Constitution, 44th Amendment, Act makes two important changes. 1. That the President does not have power to suspend Article 21 during emergency, and 2. Laws unrelated to emergency can be challenged in a court of law. In ADM Jabalpur B. S. Shukla, 1976 SC 1207, popularly known as habeas corpus case, the respondent challenged the validity of the proclamation of emergency under Article 352. The main question for the consideration of the Supreme Court was whether, in view of the President order any writ under Article 226 for habeas corpus to enforce the right to personal liberty of a person detained under the Act on the ground that the order of detention is not in compliance with the Act. The Supreme Court held that no person has any legal right to move any writ petition under Article 226 before a High Court for a habeas corpus or any other writ or order or direction to challenge the legality of the detention order, on the ground that the order is not under or in compliance with the Act or is illegal or vitiated by mala fides factual or legal or is based on extraneous consideration. The court, however, refused to follow the ruling in Makhan Singh v. State of Punjab, AIR 1964 SC 381, wherein the Supreme Court had pointed out that if a detainee challenged his detention on the ground that it violated statutory provisions or the detention is vitiated by mala fides, the challenge could not be barred because of the presidential order under Article 359, 1. B. State emergency due to the failure of constitutional machinery in states. Failure of constitutional machinery in state. Article 356 says that if the President, on receipt of a report from the governor of a state or otherwise, is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution, he may issue a proclamation. By that proclamation, 1. The President may assume to himself all or any of the powers vested in or exercisable by the governor to anybody or authority in the state. 2. The President may declare that the powers of the legislature of the state shall be exercised by or under the authority of Parliament. 3. The President may make such incidental and consequential provisions as may appear to him to be necessary or desirable for giving effect to the object of proclamation. When the proclamation of emergency is made under Article 356, 1. The powers of the state legislature are to be exercised by Parliament. Parliament can confer on the President the power to make laws for the states. Parliament may also authorize the President to delegate such powers to any other authority as specified by himself. Article 357, 1a. If the Lok Sabha is not in session, the President may authorize expenditure from the Consolidated Fund of State, pending sanction of such expenditure by Parliament. The proclamation issued under Article 356, 1, may be revoked or varied by the President by a subsequent proclamation. It is to be noted that the word satisfaction in Article 356, 1, does not mean the personal satisfaction of the governor, but it is the satisfaction of the cabinet. The satisfaction of the President can, however, be challenged on two grounds that 1. It has been exercised mala fide, 2. Based on wholly extraneous and irrelevant grounds, because in that case it would be no satisfaction of the President. A proclamation issued under Article 356 shall be laid before each House of Parliament and shall remain in operation for 2 months unless before the expiry of that period it has been approved by both Houses of Parliament. Clause 3 of Article 356. Any such proclamation may be revoked or varied by a subsequent proclamation. If any such proclamation is issued at the time when Lok Sabha is dissolved or the dissolution takes place during the period of 2 months and the proclamation is passed by the Rajya Sabha but not passed by the Lok Sabha, the proclamation shall cease to operate at the expiry of 30 days from the date on which the new Lok Sabha meets after the reconstruction unless before the expiry of 30 days it has been also passed by the Lok Sabha. If the proclamation is approved by the Parliament, it will remain in operation of 6 months. Parliament may extend the duration of proclamation for 6 months at a time, but no such proclamation shall in any case remain in force for more than 3 years. After 44th Amendment of the Constitution in 1978, a new clause, 5, to Article 356, has been added in place of existing clause, 5, which has now been omitted. This new clause, 5, provide that a resolution for the continuance of the emergency beyond 1 year shall not be passed by either House of Parliament unless a proclamation of emergency is in operation at the time of passing of such resolution, and b. the Election Commission certifies that the continuance in force of the proclamation under Article 356 during the period specified in such resolution is necessary on account of difficulties in holding general elections to the State Legislative Assembly concerned. This means that the extension of the emergency beyond the period of 1 year is possible only if the conditions mentioned in Clause 5 are available. Prior to this amendment, there was no such condition imposed and the government could extend the period up to the maximum of 3 years without sufficient reasons. The Constitution, 48th Amendment Act, 1984, has again amended Clause 5 of Article 356 and inserted a proviso in Clause 5, namely provided that in the case of the proclamation issued under Clause 1 on the 6th day of 1983 with respect to the state of Punjab, the reference in this clause to any period beyond the expiry of 1 year shall be construed as reference to any period beyond the expiry of 2 years. Under the existing Clause 5, the Presidential Proclamation of 6th October 1983, with respect to Punjab, could not continue in force for more than 1 year unless the special circumstances mentioned therein were satisfied. This was enacted to mete out the special circumstances prevailing in the state of Punjab due to Akali agitation. Having regard to the prevailing situation in the state, the continuance of the proclamation beyond 6th October 1984 was necessary. This amendment makes the conditions in the existing Article 356(5) inapplicable in case of the state of Punjab. In S.R. Bommai v. Union of India, 1994, 3 SCC 1 regarding proclamation of emergency under Article 356, Supreme Court laid down following guidelines. 1. Presidential proclamation dissolving a state legislative assembly is subject to judicial review. 2. If a state government works against secularism, President's rule can be imposed. 3. No wholesale dismissal of opposition rule states governments when a new political party assumes power at the center. 4. If President's rule is imposed only on political considerations, the court can even restore the assembly. 5. Imposition of President's rule and dissolution of state assembly cannot be done together. 6. State assembly can be dissolved only after Parliament approves central rule. 7. The Supreme Court or a High Court can compel the Union government to disclose material on whose basis President's rule is imposed on a state. 8. The power of the President under Article 356 is a constitutional power. It is not an absolute power. The existence of material is a precondition to form the satisfaction to impose the President's rule. C. Financial emergency. Article 360 provides that if the President is satisfied that situation has arisen whereby the financial stability or credit of India or part of the territory thereof is threatened, he may by a proclamation make a declaration to that effect. The 44th Amendment makes Article 360 self-contained. It provides that the proclamation of financial emergency shall cease to be in operation at the expiry of 2 months unless it has been approved by both Houses of Parliament. Such a proclamation may be revoked or varied by the President by a subsequent proclamation. But if the Lok Sabha is dissolved during the period of 2 months and resolution is approved by the Rajya Sabha, but not by the Lok Sabha, the proclamation shall cease to operate at the expiry of 30 days from the date on which the new Lok Sabha sits unless before the expiry of 30 days a resolution approving proclamation is passed by the Lok Sabha. During the period when such a proclamation is in operation, the executive authority of the Union shall extend to the giving direction to any state to observe such canons of financial propriety as may be specified in the directions and be deemed necessary by the President for maintaining financial stability and the credit of the state. Q81 discuss the scope and extent of power of Parliament to amend the Constitution. Are there any limitation on the amending power of Parliament? Ans. Amendment of Constitution with the constant change in political, social and financial spheres, Constitution also require amendments to change political society. Framers of the Indian Constitution were keen to avoid excessive rigidity. They were anxious to have a document which could grow with growing nation and adapt itself to the changing need and circumstances of growing people. So the Constitution requires some flexibility. But at the same time, framers of Indian Constitution were also aware that it should not be so flexible that it would be a playing of the whims and caprices of the ruling party. So a balanced theory was kept. Process of amendment of Constitution has not been made too rigid nor too flexible. Article 368 of Constitution of India provides the method of amendment. For the purpose of amendment, various articles of Constitution can be divided into three categories. 1. Amendment by simple majority articles that can be amended by Parliament by simple majority as the required for passing of any ordinary law. The amendments contemplated in Articles 5, 169 and 239 can be made by simple majority. These articles are specifically excluded from the purview of the procedure prescribed in Article 386. 2. Amendment by simple majority articles of the Constitution, which can be amended by special majority as laid down in Article 368. All constitutional amendments, other than those referred to above, come within this category and must be effected by a majority of the total membership of each House of Parliament as well as by a majority of not less than 2/3 of the members of that House present and voting. 3. By special majority and ratification by states article which require, in addition to the special majority mentioned above, ratification by not less than a half of the state legislatures. The following provisions require such ratification by the states. 1. Election of the President Articles 54 and 55. 2. Extent of the executive powers of the Union and States Articles 73 and 162. 3. Articles dealing with Judiciary, Supreme Court, High Court in the States and Union Territories Articles 124 to 147, 214 to 231, 241. 4. Distribution of legislative powers between the centre and the state articles to 45 to 255. 5. Any of the lists of the VI'd schedule. 6. Representation of states in Parliament, IVTH schedule. 7. Article 368 itself. Procedure for amendment. A bill to amend the Constitution may be introduced in either House of Parliament. It must be passed by each House by a majority of the total membership to that House and by a majority of not less than 2/3 of the members of that House present and voting. When a bill is passed by both Houses, it shall be presented to the President for his assent, who shall give his assent to bill, and thereupon the Constitution shall stand amended. But a bill which seeks to amend the provisions mentioned in Article 368 requires, in addition to the special majority mentioned above, the ratification by the half of the states. The question whether amendment of fundamental rights are covered by the proviso to Article 368 came for consideration in Shankari Prasad v. Union of India, AIR 1951 SC 455. In this case, validity of the First Amendment, which inserted Article 31-A and 31-B, was challenged. The Supreme Court held that power to amend the Constitution, including the fundamental rights, was contained in Article 368 and that the word law in Article 13(2) includes only an ordinary law and not constitutional amendments. Therefore, a constitutional amendment will be valid even if it abridges or takes away any of the fundamental rights. Same line of approach was followed in Sajjan Singh v. State of Rajasthan, AIR 1965 SC 845, in which the validity of 17th Amendment of the Constitution was challenged. Supreme Court approved the majority judgment given in Shankari Prasad case that amendment of the Constitution means amendment of all the provisions of the Constitution. But in Golak Nath v. State of Punjab, AIR 1967 SC 1643, Supreme Court overruled the decisions of Shankari Prasad and Sajjan Singh cases and held that Parliament had no power to amend Part 3 of the Constitution so as to abridge or take away the fundamental rights. The Constitution, 24th Amendment Act, 1971, was passed to remove the difficulties created by the decision of Golak Nath case. This amendment provides that Article 13 does not include the amendment of the Constitution made under Article 368. It added a new subclause in Article 368 which provides that notwithstanding anything in this Constitution, Parliament may, in exercise of constituent power, amend by way of addition, variation, or repeat any provision of the Constitution. The Constitution, 24th Amendment Act, 1971 was passed to remove the difficulties created by Golak Nath's case. The 24th Amendment Act, 1971, provides that Article 13 does not include the amendment of the Constitution made under Article 368. It added a new subclause in Article 368 which provides that notwithstanding anything in this Constitution, Parliament may, in the exercise of constituent power, amend by way of addition, variation, or repeal any provision of the Constitution. The validity of this amendment was again challenged in Keswanand v. State of Kerala, AIR 1973 SC 1461. In this case, the Supreme Court, by majority, overruled the Golak Nath's case and held that Article 368, even before the 24th Amendment, contained the power as well as the procedure of the amendment. As regards the scope of the amending power contained in Article 368, the Court said that the word amendment has been used in various places to mean different things. In Article 368, it means any addition or change in any of the provisions of the Constitution. The fundamental rights cannot be abrogated, but they can be amended reasonably. The Court further said that every part of the Constitution can be amended provided in the result the basic feature of the Constitution remains the same. The Constitution, 42nd Amendment, Act, 1976 to remove the difficulties created by the Supreme Court decision in Keshwanand Bharti v. State of Kerala, the Constitution, 42nd Amendment, Act, 1976 has added two new clauses, 4 and 5, to Article 368 of the Constitution. Clause 4 provides that no constitutional amendment, including the provision of Part 3, or purporting to have been made under Article 368 whether before or after the commencement of the Constitution, 42nd Amendment, Act, 1976 shall be called in any court on any ground. Clause 5 declares that there shall be no limitation whatever on the constituent power of Parliament to amend by way of addition, variation, or repeal the provisions of the Constitution under this article. In Minerva Mills Limited v. Union of India, AIR 1980 SC 1789, the Supreme Court held CL 4 and CL 5 of Constitution 368 as void because through these clauses all limitations on the amending power of Parliament were removed. The court held that Parliament cannot have unlimited power to amend the Constitution. Limited amending power is the basic feature of the Constitution. The court, however, held that the doctrine of basic structure is to be applied only in judging the validity of amendments to the Constitution, and it does not apply for judging the validity of ordinary laws made by legislature. Q80 to write short note on A. Concept of basic structure. B. Doctrine of judicial review. Ans. A. Concept of basic structure. Theory of basic structure. A limitation on amending power. The validity of the Constitution, 24th Amendment, Act, 1971, was challenged in Keshwanand Bharati v. State of Kerala, AIR 1973 SC 1461, popularly known as the Fundamental Rights case. The petitioners had challenged the validity of the Kerala Land Reforms Act 1963. But during the pendency of the petition, the Kerala Act was amended in 1971 and was placed in the 9th schedule by the 29th Amendment Act. The petitioner were permitted to challenge the validity of 24th, 25th and 29th Amendment to the Constitution also. The question involved was as to what was the extent of the amending power conferred by Article 368 of the Constitution. On behalf of the Union of India, it was claimed that amending power was unlimited and short of repeal of the Constitution any change could be effected. On the other hand, the petitioner contended that the amending power was wide but not unlimited. Under Article 368, Parliament cannot destroy the basic feature of the Constitution. The court by majority overruled the Golak Nath's case, which denied Parliament the power to amend fundamental rights of citizens. The majority held that Article 368 even before the 24th Amendment contained the power as well as the procedure of amendment. The 24th Amendment merely made explicit what was implicit in the unamended Article 368-A. As regards the scope of amending power contained in Article 386, 6 judges held that there are inherent or implied limitations on the amending power of Parliament, and Article 368 does not confer power to amend the Constitution so as to damage or destroy the essential elements or basic features of the Constitution. The court by majority of 7-6 held that the Parliament has wide powers of amending the Constitution and it extends to all the articles, but the amending power is not unlimited and does not include the power to destroy or abrogate the basic feature or framework of the Constitution. What is the basic structure? What then are the essentials of the basic structure of the Constitution? Although the judges enumerated certain essentials of the basic structure of the Constitution, but they also made it clear that they were only illustrative and not exhaustive. They will be determined on the basis of the facts in each case. According to Sikri, CJ, the basic structure of the Constitution consists of the following features: 1. Supremacy of the Constitution. 2. Republican and democratic forms of the governments. 3. Secular character of the Constitution. 4. Separation of powers between the legislature, the executive, and the judiciary. 5. Federal character of the Constitution. In Indira Nehru Gandhi v. Raj Narayan, AIR 1975 SC 20-99, the Supreme Court applied the theory of basic structure and struck down CL.4 of Article 329-A, which was inserted by the Constitution, 39th Amendment, Act 1975 on the ground that it was beyond the amending power of Parliament as it destroyed the basic feature of the Constitution. The Supreme Court has added the following features as basic features of the Constitution to the list of basic features laid down in the Keshwananda Bharati's case. 1. Rule of law. 2. Judicial review. 3. Democracy, which implies free and fair election. In Minerva Mills Limited v. Union of India, AIR 1980 SC 1789, Supreme Court has held that the following are that basic features of the Constitution. 1. Limited power of Parliament to amend the Constitution. 2. Harmony and balance between fundamental rights and directive principles. 3. Fundamental rights in certain cases. 4. Power of judicial review in certain cases. 42nd Amendment and Article 368 after the decisions of the Supreme Court in Keshwananda Bharati and Indira Nehru Gandhi cases, the Constitution, 42nd Amendment, Act 1976, was passed, which added to new clauses, namely, clauses 4 and 5 to Article 368 of the Constitution. Clause 4 provided that no constitutional amendment, including the provision of Part 3, or purporting to have been made under Article 368 whether before or after the commencement of the Constitution, 42nd Amendment, Act 1976 shall be called in any court on any ground. Clause 5 removed any doubts about the scope of the amending power. It declared that there shall be no limitation whatever on the constituent power of Parliament to amend by way of addition, variation or repeal of the provisions of the Constitution under this article. In Minerva Mills v. Union of India, AIR 1980 SC 1789, the Supreme Court, by 4-I majority, struck down clauses 4 and 5 of Article 368 inserted by the 42nd Amendment, on the ground that these clauses destroyed the essential feature of the basic structure of the Constitution. Limited amending power is a basic structure of the Constitution. B. Doctrine of judicial review. In most of the countries with a written constitution, the judiciary performs the role of an authoritative expounder of the Constitution. This role of the judiciary stems from the feeling that a system based on written constitution can hardly be effective in practice without an authoritative, independent, and impartial arbiter of constitutional issues, and to check power being exercised by a governmental organ which is not sanctioned by the Constitution. The Indian Constitution, however, explicitly establishes the doctrine of judicial review. The relevant articles are 13, 32, 131 to 136, 143, 226, and 246. The doctrine of judicial review is thus firmly rooted in India, and judiciary has many a time enunciated it. In Madras v. V.G. Roe, AIR 1952 SC 196, the Supreme Court has stated that our Constitution contains express provisions for judicial review of legislation as to its conformity with the Constitution. Similarly, in A.K. Gopalan v. State of Madras, AIR 1950 SC 27, the Supreme Court declared, in India it is a constitution that is supreme and that a statute law to be valid, must in all cases be in conformity with the constitutional requirements, and it is for judiciary to decide whether any enactment is constitutional or not. The court further held that in so far as there is any limitation on the legislative power, the court must, on a complaint being made to it, scrutinize and ascertain whether such limitation has been transgressed, and if there have been any transgression, the court will courageously declare the law unconstitutional, for the court is bound by its oath to uphold the Constitution. Rule of literal interpretation. The basic approach of the Indian judiciary has been to interpret the Constitution literally, like an ordinary legislative enactment. This is known as positivist approach. In Chiranjit Lal v. Union of India, AIR 1951 SC 56, the Supreme Court has laid down the principle in these words: in interpreting the provisions of our Constitution, we should go by the plain words used by the Constitution makes. In interpreting the Constitution, the courts in India have mostly applied the same principles as are applicable in the construction of a statute. This has been the dominant approach, though at times the Supreme Court has taken care to emphasize that the Constitution must not be construed in any narrow and pedantic sense. The principle of broad and liberal interpretation has been consistently applied to the construction of legislative entries in 3 lists. The entries are to be given a broad sense beneficial to the widest possible amplitude of powers and a narrow and restricted constitution. They include within their scope and ambit all ancillary matters which legitimately come within the topics mentioned therein. Principle of harmonious constitution. The Constitution should be so interpreted so as to give effect to all its parts, and the presumption should be that no conflict or repugnancy was intended by the framers between the various provisions of the Constitution. It is, therefore, laid down that in case there are provisions in the Constitution which cannot be reconciled, the provisions should be so interpreted that, if possible, effect should be given to both. That is what is known as the rule of harmonious construction. This rule is used to resolve the conflict between the various provisions of the Constitution while interpreting the Constitution for its judicial review.